Procedural item 1.
Yes. There is an amicable settlement out of the court lordship. There is an amicable settlement between the parties out of the class. So they will withdraw. Stay, stay is there. That is, stay is also there. Has to be located. Instructions to withdraw the issue. Accordingly, parties will appeal to the power. What order is this? What's it? 22 matrimonial dispute. It is regarding matrimonial divorce suit. It was a divorce suit. Which order you are telling me? What the interim orders? Serving with the interim order past 2022 stands with you. Deeply.
Top of the list, item 2.
People recall it was hard by Lockheed for something. The 40,000 one. Yes. Well, one submission I would like to make subject to lots of consideration. Although he has paid for declaring the declaring the gift deed void, but certain things are there, like the advance that he took, admittedly, he did not pay for a decree to refund that advance. Number one. Secondly, my lord, that agreement to sell is also there, admittedly. He did not pay for setting aside the agreement for sale also. That shows that his intention is there to sell. And what all that he wants is the consideration money. So far as possession is concerned, my lord, there could a plea that possession was not delivered, but his own witness has come forward and said that I have delivered possession only on the instruction of the claim. So that part is also there. In that view of the matter, my lord, my first submission will be in terms of, as you lordship indicated on the last occasion, transfer of property, my lord. Section 55. My submission, my lord, under section 55, the obligation
55 will only come once a sale deed is done.
done, man. Yes.
But we have to consider that there is no
I
sale
understand,
deed.
madam. I understand. Only after selling. But then, lordship, because lordship kindly goes to section 55 once. 55D says, 55 starts with these sentences, madam. In the absence of a contract to the contrary, the buyer and the seller of an immovable property, respectively, are subject to the liabilities and have the rights mentioned in the rules next following, or such of them as are applicable to the property sold. Number one, the seller is bound. A, B, C, I'm skipping my lord. D says, on payment or tender of the amount due in respect of the price, to execute a proper conveyance of the property when the buyer tenders it to him for execution at a proper time and place. So that shows, my lord, if full payment is made, then he has to execute this deed. Now, my submission here is, assuming, although he has taken a plea that I have not paid the balance amount, and I show from the evidence from our side also, we have said that full payment was made actually. And
But
assuming
that is a finding of fact that the full payment has not been
my
made.
lord, so my submission will be, if he doesn't challenge the advance agreement to sell, and if he doesn't say that I am going to refund the advance which I took, that means his intention to sell is still there. In that view of the matter, my lord, if we convey the remaining, pay the remaining amount, assume if we accept that the finding of fact by the two courts below is that I have not paid, in that event, my lordship may mold the decree and direct me to pay the balance amount and execute this.
You filed a counterclaim.
I have the file,
Well,
but I have not filed a
how do I do that?
But I have not filed counterclaim. I'm saying that whether the
Only molding of the relief can be
fine.
a question of specific performance. You can be at liberty to file a suit for specific. That can be the only molding of relief. Because you have, I would have understood if it was a counterclaim that you have filed.
My lord, that was
I
a
can't-
mistake.
I
mistake on our
can't
part.
mold the relief which is not there itself. You have never sought for.
My lord, there's one judgment of more or less same type of text. I'd like to rely on that. There a release deed was executed, then the Supreme Court said no.
But it was executed.
Release deed was executed. And similar type of plea was taken that it was or got executed through fraud, etc. Very short judgment. My lord. First paragraph I would like to read for the purpose of showing that texts are more or less similar. In this appeal, the question is whether a deed of release was vitiated by misrepresentation, and if not, whether it operated as conveyance of the properties in favor of the respondents. By a will dated so and so, their grandfather bequeathed the immovable properties to his paternal uncle's daughter so and so. In January 1952, the respondents instituted so and so case against the several persons, including Kannamal, challenging internally the validity of the bequest made by Ponnuswamy. On so and so, Kannamal died leaving as her heir the appellant who was her husband's brother's son. On so and so, the appellant executed a deed, Exhibit B1, in favor of the respondents, releasing the suit properties, including certain outstandings due from third parties. On so and so, the deed was registered. On the same date, the respondents filed an application in so and so, asking for an order that in view of the release deed, the properties removed from the scope of the suit and the plaintiff be amended accordingly. This application was allowed by the court. On so and so, respondents instituted OS number so and so for the recovery of one of the outstandings mentioned in the release deed against the debtors. They pleaded the appellant as a defendant to the suit and stated that in view of the release deed, they were entitled to recover the debt. The appellant filed a written statement alleging that release deed was invalid and suit was not maintainable. The suit was decreed by the municipal. On so and so, the appellant instituted present suit asking for a decree for setting aside B1, like asked my lord, recovery of the suit properties and accounts. He alleged that B1 was vitiated by misrepresentation, fraud, deceit, and undue influence. His main contention was that he was induced to execute the deed on the representation that it was a power of attorney, authorizing the respondents to manage the properties on his behalf. He also submitted that Exhibit B1, being a deed of release, would not take effect as a conveyance.
Was your agreement for sale a registered instrument?
My lord,
Was your agreement for sale a registered instrument?
but our gift deed was released. What I am trying to rely on from the judgment, my lord. This Exhibit B1, the plaintiff alleges that it was got executed through fraud and misrepresentation, etc. The court disbelieved and said that even if it is a release, it can be.
It can be still treated as a conveyance.
Yes.
There's no quarrel with that proposition. But the fact that here you have got a gift deed executed.
Yes.
And there was an agreement for sale, you have executed a gift deed.
Right.
Now the question is that the gift deed has not been executed is the finding of fact. by the courts below. But that was not the question before them. And Supreme Court says that a release deed, if it is in the form of where there is a certain consideration is given, everything can be very well treated to be a conveyance. That's the what is the proposition. But here the gift deed is in challenge and the gift deed has been said to be bad on account of that he did not sign it.
No, my lord, not that. They did not say we did not sign. They say that we signed. Like this case, here they have taken a plea that I thought it was a forfeit only, so I signed. In our case, they say that I thought it was a sale deed, and then I signed. Signing the, it's not disputed by me. Slightly. Signing is not disputed. They say that we went to the office of the sub-registrar thinking that as instructed or as agreed to by the parties, a sale deed was prepared, and accordingly we signed. And long after that, they filed the suit. Agreement for sale was also registered.
It's okay.
And one more aspect, my lord. In the cross-examination, PW1 says that there are other defendants, my lord, who purchase other part of the property on the basis of same sale agreement to sell, my lord. For them also, there was a gift deed, not one, two, three gift deeds. But I have not challenged those because I got the full amount. So he doesn't have any objection even in execution of a gift deed also, my lord.
So the fact that the sale deed was, the gift deed was executed is not in dispute.
No, no.
What is in dispute is that they have nomenclatured it as a
Yes,
gift deed
yes.
instead of a sale deed.
Exactly.
Now, the amount of 40,000 having been, was paid or not, has it been proved?
Exactly.
Then why not let us come to 5,
Fine.
55, 5.
Fine.
This is what I said last time.
Yes. Buyer is found. To disclose, to pay. Yes. B says to pay or tender at the time and place of completing the sale, the purchase money to the seller or such person as he directs. And as your lordship is absolutely correct. So here, the buyer has a obligation. I am bound to pay the amount. If it is found that I have not paid the balance amount, so I'll be bound to pay the balance amount, provided that where the property is sold free from encumbrances, the buyer may retain out of the purchase money the amount of any encumbrance on the property existing at the date and shall pay the amount to retained persons entitled.
Can we come to 4B?
Yes, that's what I mean. Where the ownership of the property is passed to the buyer before payment of the whole of the purchase money, we charge upon the property in the hands of the buyer, any transferee without consideration or any transferee with notice of the non-payment for the amount of the purchase money or any part thereof remaining unpaid and for interest on such amount or part from the date on which possession has been delivered. And in our case, my lord, there is a specific evidence that possession was delivered. Although the finding says that possession is with the plaintiff.
So, in terms with 55(4)(e),
Four B, my lord.
4D,
My lord.
the seller, if the amount has not been paid, would have a charge on the property.
Proportionate.
Charge on the property in respect to the amount which had not been
Not
paid,
paid. Yes.
and the interest accrued thereon,
Yes.
and nothing beyond.
Yes.
Even if it is held,
Yes.
that if it is a gift deed, the gift deed or sale deed, whatever may be,
Because by virtue of the gift deed also, ownership is stands transferred because it's a registered document. And one more aspect, my lord. There was a question in the cross examination. Let's see, in the say gift deeds under challenge, it is mentioned that they are friends and relatives. Then a question was asked that in respect of other gift deeds of the same plot of land, based on the same agreement to sell, there are some gift deeds which you have not challenged. He said, yes, I did not challenge because I got the full amount. Then another question was that, see, there also it is mentioned that they are your friends and relatives. Are they? He said, no, they are not my friends and relatives, but still it is mentioned as they are my friends and relatives. In the other gift deeds of the same plot of land and on the basis of the same agreement to sell. So in that way, my submission will be subject to your explanation. That his plea that it was executed through misrepresentation is not correct. Because he has not challenged the other. If he is not accepting the gift deed, he could have challenged all the gift deeds. But other gift deeds he has accepted and same wordings are mentioned in the same gift deed. Other gift deeds.
finally come to paragraph number page 115, paragraph 24.
The real fact of the suit is the suit land described in schedule 4.
We are concerned with whom? What is your name?
Noni Borwa.
You are Noni. And the others are not party. Biren Boro,
Others are pro forma, my lord.
Bora. Who are they?
I am different number 1 and 2. Noni and Mukul.
Noni and?
Mukul Hajarika.
No. What about the others? Biren Bora, Horen Bora, and Madhav Bora?
Others, my lord, this was regarding the other 10 because this is in respect of the remaining part of the land, my lord. They have purchased the remaining part.
So this is in respect to those others, Horendranath Borua, Lokhiram Bora, Jibon Bora, Bolon, they decided to purchase this. So there are give deeds.
There also, yes,
No, you have mentioned it in your evidence.
yes.
And when cross-examining that there are certain gift deeds.
In the special.
And have you challenged it? He says that I have not challenged it because I have received them.
Yes.
It is in connection with these other.
Yes.
Did you file any suit? No.
No.
Although you crave leave.
Fine. Second paragraph, page 117, we mentioned like.
So don't you think that we have to now frame a substantial question of law in view of 55? Oh. So without framing it,
Okay.
may not be possible for deciding it,
Fine.
giving them an opportunity to appeal. Because the other substantial question of law does not hold good.
In view of the present deliberations, when other substantive questions may not be.
After was heard Mr. B. Majumdar, the learned counsel, advising, sir, appearing on behalf of the, on hearing, matter at length. This court is of the opinion that the substantial questions of law so framed on 21/1/2009 prima facie appears to be not substantial questions of law involved in the instant appeal. However, Mr. D. Majumdar, the learned senior counsel, drew the attention of this court to certain facts, which have been duly admitted, as would be apparent from the evidence. He submitted that the fact that how many did we give this?
Three more.
The fact, no. Your is how many give this he had challenged?
Three.
The fact that the give this, the claim,
419-420-421. 8 number.
the fact that the deeds which have been more specifically described in Schedule 4 to the claim, having been admitted to have been executed by the plaintiff, And the only issue involved is, and the only grievance of the plaintiff was that he did not receive the remaining part of the consideration. The length part of the consideration for which the suit was filed. A substantial question of law is involved in the instant appeal. The learned senior counsel therefore proposed that therefore submitted that this court ought to frame a further additional substantial question of law. This court, upon hearing the parties and upon perusal of the materials and report, is of the opinion that the following substantial question of law, and is the opinion that an additional substantial question of law can be formulated in the instant appeal in terms with section 100 bracket 4 of the code. The said substantial question of law, the additional substantial question of law reads as under: whether the courts below were justified in decreeing the suit in favor of the plaintiff when it was an admitted fact that the plaintiff had duly executed the deeds specifically described in Schedule 4. And the question and the grievance of the plaintiff could have been taken care of by the provision of section 55, bracket 4, bracket B of the Transfer of Property Act 1882. So taking into account that an additional substantial question of law have been framed, this court gives an opportunity to the respondent herein to address this court as to whether the above substantial question of law so framed is involved in the present appeal. Accordingly, lists this matter on when you need to try harder this time. Earlier you had a case. Now this is a very important point. I don't frame additional substantial question of law. If I frame, I think that there is a case. Let me come back on 22nd of April at the top of the list. Well, the other three does not remain. So here the question would be, the court, in view of the fact that it is a conveyance, the title having been gone, there would be a charge on the said amount along with interest to which he will be entitled. Interest we have to put it, how many years in the suit?
2009.
Today is
99.
2024. Okay, we put at 18%. 18 or 19% we put the interest per year. 18% vegetation.
Item 3,
Sir, waited. I understand he is due to return. Yes, but this matter.
Oh, no. This has to be done as soon as possible.
Kindly pay those paragraph number 7 of your lordship last order, man.
I
I
am
have informed them, but if it may please be taken up on Monday, subject to the
2
convenience
o'clock,
regular.
2 o'clock. This is a correction which was required to be made. The question arose out here as to whether you have put the correct date in your record. Because tomorrow if he retires, it will have a consequence. Therefore, I asked you to get hold of
Yes.
the service book
Them, mother. And
as well as
Monday.
service book. What was the date being put? And whether at that time
Yes.
or when the service book was prepared, he had placed the HSLC admission.
Yes. that has been asked for. Lordship takes it up on Monday, subject to the convenience of the song. I'm yet to receive.
Monday is what date?
Can be taken up on Wednesday also, subject to the convenience.
Tomorrow.
No, ma'am.
No, tomorrow.
No.
Wednesday is
No,
tomorrow.
not on the next
Don't-
week.
No,
Monday.
madam, kindly don't come up with all these things. I
Monday.
have specific area. Now, who is them? I've asked them to bring it. Why they have
Yeah,
not brought it in
Hemadi
spite of
Malad.
an order?
TJM Hemadi.
Huh?
TJM Hemadi.
CGM Demaji,
Yes.
ask him to bring it. At 2 o'clock? Let us hear the CGM Demaji at 2 o'clock in this. Give him all the this. We'll hear him at 2 o'clock. Why he has not been able to send this. We provide ask the CGM
will
Demaji to be
take the
present through the video.
I'll have the.
Because I'll ask him this, whether this is this. These are the two things. So
Very
that
straightforward.
later on it cannot happen. Because I will have it again on Friday and finish it.
But,
Order has to
Friday.
come out, dictated, signed, published.
Malad,
Into the-
Friday.
Have other, madam, you see, you have personal difficulties, I understand. No quarrel with that. But the fact remains that we are concerned about the person's name.
Yes. Future.
Because once he gets delayed, he'll have far-reaching consequences. You never know what are there in future.
Yes. 2 o'clock. I'll have the arrangement.
We'll ask him, I'll only ask him to be present out there
Online.
along with the service.
Yes.
for admission, item 5,
Oh, this one. Where is he? So we dismiss it. None is appearing on behalf of the petitioner. I asked him to vacate it, didn't I?
That might not bear on land grabber.
And ACC. Oh, I remember. There's a proper report given to that where they have gone inside the second portion of the land. So none is appearing, so we dismiss for default. We dismiss it at
I am suffering.
but the thing is, if he is not appear, can only dismiss for.
There only originally it was Decretal. And
And names have been shown in the cause list, Sahiwala's name.
shown as Decretal.
Oh. They have taken that advantage.
He is earning my lord, about mine and my lord.
So, but the thing is, they will If I dismiss, they will come with again another. Understood. The reason is them. The problem is the High Court. They have made that mistake. Oh, I couldn't sound. Was the AR decision? এই ওকালতনামা সাকসেস ওকালতনামা ফাইল করা নাই
Kalanamai is not filed by Arora. That side is no Kalanamai. Within my name is expected.
ট্রাভেলক মাথা বলো will take after some time.
For hearing item 10.
Yes, Mr. Sayola. This item number 5. First of all, you have not filed your wakalatnama. No, there you have not filed the wakalatnama. That is the problem.
Well, I have also asked for some instruction from the department, my lord. Can it be, my lord, after 2 weeks, my lord? For instruction,
But the question doesn't arise. No, I will fix a date. I was supposed to finish it off today. I gave you an additional opportunity. That before dismissing it, I gave you that can
My
you
lord, my lord,
go for an out of court settlement. You are not interested in that. Huh?
The passport has not made any communication.
No, you are not interested. And now I can't put it in your name because nobody has filed a wakalatnama. So we dismiss it for default,
My lord,
none an appeal.
that will be done, my lord.
No, we'll vacate the interim order.
My lord, of 2 weeks time may be granted.
No.
2
You
weeks
have
time may
not
be-
filed wakalatnama. Your appearance on that day was absolutely uncalled for.
Well-
First, nobody could have appeared. There's no wakalatnama filed.
My lord,
And how did you appear out here?
2 weeks time may be granted.
No, I'm vacating the interim order.
Well, but because they have fixed for standing council, my lord.
They have changed the standing council, whatever may be. Then also you are required to file the wakalatnama. Is it not required to file a wakalatnama if you are standing council? Standing council of a department, you have to file. We vacate this interim order. I've already recorded on 18th, on last occasion, that this court does not find any good ground to interfere. Under 227. As none has appeared, so we dismiss the petition on merits. None has appeared on behalf of the.
Yeah,
The criminal case will be against the managing director of ASTCS.
that is going on.
Criminal, let the criminal case
But
go
waiting
on.
for result of this.
Huh?
And that is going on, and the criminal is going on, but they are waiting for result of this. case.
We'll do one thing. None appears on behalf of the petitioner on call. Mr. DCC Pupun, the learned counsel, appears on behalf of the respondent. Proceed. Taking into account the order dated 13/2/2025, wherein it is seen that Mr. G. N. Sahewala, the learned senior counsel assisted by Ms. S2D, had appeared on behalf of the petitioner. And in the cause list, it has been shown that their names have not been reflected. This court fixes this matter on today, what? On 23/2025 at 2 p.m. Houston. The registry shall first inquire as to whether any wakalatnama has been filed on behalf of Miss S2D in the same matter in the instant proceedings, and thereupon place the note before the court. The names of Mr. G. N. Sahewala and senior counsel and Miss S2D be also reflected in the cause list. We finish it off on second. On
Can it be on next Tuesday, my lord?
no, I won't. We finish it up. This type of matters cannot remain. And if you have not filed, Mr. Sahewala, if you have not filed the wakalatnama earlier, and there is an appearance by this court, please don't mind. I will refer this matter to the bar council. Because there is somebody who has to appear. Yes, item number 10. Yes, tell me.
May I call after 5 minutes, your lordship?
Where is the next bill? Next matter. None appears on behalf of the appellant, which the matter up to 2 weeks.
Item 13,
Yes. Yes.
This is regarding Milord, it. Actually, this Milord, the, and the appellant and respondent, they are Milord, the, from same family Milord. The Abdul Latif Khan, he had some property in town Milord.
What happened? Suit was decreed.
Quickly. I
Appeal was dismissed.
I finally,
Yeah, so the suit was for the purpose of partition. Suit is for partition.
notice for Milord,
Influenced by the, us, that was decreed in favor of us. So for
student for
partition,
declaration of shares,
Yeah.
partition and.
So you
transposition.
filed the suit for partition.
partition and share,
Then what happened?
then suit was decreed in favor of.
No, no. What was there plea?
They were the decision. Their plea was that the father made oral gift to them. Then
So,
they,
so that is the question.
that's the question. They
Now
went
let
to
us
appeal.
see their written statement. The proof for partition is not that in the last 40 years the plaintiff has been
Restatement, my lord, page
keeping
15.
a connection with
Paragraph 6.
where is the averment made in the written statement as regards the gift?
My lord, page 16, paragraph 6.
Para
Paragraph 6.
6.
Page
Entire
16.
land of so and so has been orally gifted to the defendant number 2, defendant number 1, and so and so, and gave delivery of possession. Accordingly, later on, they had partitioned 35, sum number 35, by creating 3 dogs, so and so, so and so, so and so. So this is the averment.
Right.
So for the purpose of a gift, what is required are the 3 requirements. That's his intention. He is an intention. Then there you go. You can go to Mullah.
That
Eh,
is, my lord,
Mullah.
deliver a
Intention.
position and acceptance.
Eh?
Deliver a position and acceptance.
Delivery, possession, and acceptance. These are the 3 requirements.
Case 3 has been completed, complied in this.
So
case,
you
my lord.
say out here that it has been orally gifted.
Lord Condol, my lord, yes,
Now,
it
what does the learned trial court hold?
Ma'am.
Whether the issue is there, distributed the property area. Issue number 6,
was number
Mullah.
6, two.
common law. Nikon.
And page 25, my lord, that we discussed.
Issue number 6, how it is decided, let
Yeah.
us see.
5, 6, 7. Oh, sorry, my lord.
PW1 has deposed that so and so was the owner of the possession of the area, schedule ABC.
Paragraph 24 is there, my lord. PW1.
Where is the discussion on gift? Huh? By the trial court?
Page 24, my lord, in middle, the lordship may kindly see, DW4 deposed in his evidence that.
Where?
Paragraph page 24.
Deposed in his
middle-
evidence that the entire land on the patta number so and so, so and so, so and so.
also has been orally gifted by their father, late
Manor
Abdul
of
Latif Khan.
is gifted to the defendant number 2, to this deal and to defendant number 1, and Shira to Nurul Aminai. He also deposed that schedule A was allotted by the father to so and so. In his crossover, DWP stated that he cannot say exactly when VCB land was gifted. Further deposed that he does not remember whether he had mentioned the fact in whose presence VCB was gifted. So the only DW4 has stated the plea of gift of
we have
allotment of
stated, but
so is taken by
Capital 1, 2, 3, 4, there is chairman there.
I suppose that the entire land in Patta number so and so was gifted by the so and so and gave delivery of possession period so and so, so and so. In his cross-examination, stated that he has not mentioned in his evidence and written statement it of the gift. The witness in presence of whom his father had gifted him, and also that he had not stated in which state and in presence of whom the father had gifted, and he denied suggestion that no such gift was made. So how does the court deal with this issue?
Page 25, that is discussed, Mulana. Upon perusal of the entire evidence on record, it is seen that the page 25, Milord, second paragraph.
Any evidence to prove the alleged gift of the suit led by the father, leading the report that so and so made the oral gift here, but the law requires the oral gift so made by be proved by evidence. The oral gift on the minor shall be made in presence of witnesses. EW1 had not deposed when in whose presence the gift was
EW1
made.
has not
EW2 failed to prove before the time and of whom the gift was made. EW3 has denied the gift. EW was deposing it. Defendant will not. So the gift goes like that. Now, what does the appellate court say?
Absolute court, Milord, page 41, Milord, is the issue. Paragraph, serial number 6, Milord. And discussion, Milord, starts from
Issue is very
43. Issue number 5, 6, 7 together, Milord.
Did you say all these things? DW1, it appears that he does not know anything about the gift allegedly made by Abdul Latif in favor of the defendant. Any evidence? Did you say this?
No, Milord,
And DW2 says, in his evidence, admitted that if the plaintiffs are the sons of heir, they will inherit the property of so and so. Did you say that? Therefore, from the evidence of delay, it is presumed that no gift was made. P. So and so in his way admitted that he does not know anything about the suit land. D3, it is clear the defendant failed to examine. 4. So and so. Now, Mr. Counsel, what do you mean by declaration of a gift? Declaration, how it's to be made?
Milord,
Can you make it by a whisper? It has to be known to the people. Don't you think so?
oral gift that was made. Milord.
Well, very well. But can a declaration be made by a whisper without knowing to anybody else? Whom did he say?
As per that oral gift, Milord, that land was, Milord, located in their names. Their names were persons of legal heirs. But two sons, they were not given as because they were, Milord, directly declared or so, Milord, and they were, Milord, driven out from the house, and that, Milord, they took some money from the father of the, Milord, your appellant. 17,000 at the time, Milord. And they also made a declaration that they will not make any claim in future, Milord, for the property. So, Milord, they are not given any share, Milord, in the property. And there are three essentials, Milord, of the deed, Milord, that is your lordship, Milord. I tell you that
It's okay, you may have the other two, but where is the declaration? How did you prove the declaration? Post, it is, isn't it say, there is one judgment, a beautiful judgment in the Supreme Court, it says,
my lord,
the
one,
all
one
three
judgment,
are
one judgment I have,
sequential.
Milord. Your lordship may kindly see.
First, there has to be a declaration. Secondly, it has to be delivery. Third, it has to be accepted. There cannot be an acceptance first or delivery first. First, there has to be a declaration. Now, how did you prove declaration?
Declaration means whether land is there and then.
No,
The
no,
person
no.
who made the.
It is a declaration
Yes,
to the
made the
people that look here, I have given this land to so and so. I've gifted this land to so. Where is the proof of being declared? Without first being complied, second and third, we will go later. Let us see DW2. You have to prove that. Trust
Your
me.
lordship may kindly see judgment, Milord, of the court, Milord. It was 1992 GLP 490.
No, there are many more judgments I have delivered in this point. But first, recently I have delivered one judgment. Eh, sir, नोकरी तो this is not gift होता था. सारा सिले किसको? These 3 weeks of gift. Oh, this is recently this week. Anyway, let us see what is the cross.
Proceed.
Who is PW1?
PW 4, Milord, is Mondol, Lat Mondol.
No, Latmandal. Latmandal will come later on. First, where is the declaration? Okay. PW1. Where is come? I am the defendant. The suit is not maintainable in law. The suit is for partition without making party the so and so the suit for cast. That several years, that from several the plaintiff did not keep any connection with the brand nor held a so and so. Was the original patta number so and so, drug number so and so of the patta land has been already gifted by my father to myself with E. Defendant number 1, E, and so. Nurul Amin and gave delivery of possession of the same. Accordingly, later on, we have partition so and so allotted to Abdul Rashid Khan. Filing a written statement is this. Exhibit 1 is so and so copy. It is not a fact. Nur Alam has not executed any document by relinquishing his share. The scoop land has approximately so and so. Originally, so and so should then belong to Late Abdul Latif. When the plaintiff and my stepbrother, they are sons of Abdul Latif, the suit in the area of so and so. The plaintiff has not filed this suit for partition. Filed the suit. I have not mentioned in the man of the affidavit the date of the gift and the witnesses in presence of whom my father gifted the scheduled land to me. I have not mentioned in my evidence on affidavit the date of the gift of the in presence of either gifted to so and so. I have not mentioned in the written statement in my gift whom present so and so. There is no any payment relinquishment deed executed by the plaintiff number one, registered relinquishment in respect of the share of the paternal property. It is not a fact that plaintiff number one claims month of sale. It is not a fact that in the month of Iman, so the gift it is in the name of so and so. I have not mentioned the date of the. This judge, whoever is written, his handwriting is horrendous. I do not know why I was called as a witness. Who is number two?
PW Milord. Follow the bench. Very good.
Yes, where is the perversity?
It is implied when the land is Milord liquidated in the name of the
Mutation is different. Where the perversity as regards declaration. You did not prove anything. No witness. Now you don't know before whom he made that. Where's the perversity to that?
The submission of your lordship is the, there are three conditions and three conditions are fulfilled. And there is a regarding declaration, and second will have land,
Answer.
hand over the
First
position,
condition
and
can
third
be-
will have the
The
acceptance
first
of the
condition can only be
These are
fulfilled.
fulfilled, will have-
First condition can only be fulfilled if the second condition, first, second, and third has to be fulfilled. Now, in this case, there is no fulfillment. But the case of my judgment is a decision. I say the gift of condition. It's a
will have-
recently. Judgment is a decision. Three conditions to be fulfilled. Again, I know. Some recent Supreme Court judgment. But where is the question of where is the perversity in the judgment? The court says that you have failed to prove it on the basis of evidence. Well, what is the evidence which will show that there is a delivery declaration? Where is the evidence for declaration that he had declared that this way? You have to fulfill the three requirements.
Someone
Declaration,
says it's hate in our favor, but date we cannot say.
no, where's the declaration that I am giving it? In
There is-
your,
There is no any declaration, written declaration, my lord, but.
no, not written declaration, orally declaration, where is it? It has to be made before some person.
But some person should be.
Then where is it?
support.
You don't know anything. You have not proved. That is the first requirement has to be proved. Second comes delivery, possession, delivery of possession. Third is acceptance. And all are sequential. A recent judgment says of the Supreme Court that you cannot have P, that is delivery, prior to declaration. You have to meet the three. And this
And
is the
in
finding.
In this case, while the submission of lordship, declaration was there, and on the basis of
Where
declaration.
is the
draft
declaration
order
before
and the
whom?
circular officer
Where is your
stated our
submission?
names, my lord.
Full officer is not there. Where is the submission as regard declaration? Where is your statement that there was a declaration made before somebody?
Before somebody will put, there is not there in the
And-
statement. And remember, but we have stated in the application written statement and as well as in our evidence, my lord, that it is gifted property, and on the basis of that gift, my lord, or that declaration, our names are included in the land, my lord. So, and we are in possession, and we have accepted the declaration of our gift, my lord. So,
That cannot happen. That cannot happen. Declaration has to be based on something. Hello? We dismiss it. Judgment হলে ভালো ছিল। Yes, show me something.
Lordship, latest judgment of the Supreme Court, that is para 25 and 26. One has to follow another law. For declaration, then
Ah.
acceptance, then lordship.
This is the judgment of the
Latest December lordship.
he has referred to is
Para 25, 26. lordship.
It is a fact that the requirement for the validity of a gift deed are sequential. One must follow the other. The latter can only hold water if the first one is complied with. In other words, if A is not complied with, B and C would not be of sequence. Yes, I've referred to this. Some case I forgot. Simply. Hello. I hope. Or Mr. So-and-so, the learned counsel appearing on behalf of the appellant, and Mr. So-and-so, the learned counsel appearing on behalf of the respondent. There is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 24/6/2015, passed in title appeal number 6 of 2014, whereby the court of the civil judge Gwalpara, hereinafter referred to as the First Appellate Court, had dismissed the appeal, thereby confirming the judgment and decree dated 10/4/2014, passed by the Court of the Learned Munsif number 1 Gwalpara, hereinafter referred to as the Learned Trial Court, in title suit number 114 of 2010. It is seen from the records that on 2/5/2016, this court had admitted the instant appeal by formulating the following substantial question of law. Friends. The question arises in the instant appeal as to whether the said substantial question of law so formulated is involved in the instant appeal. For the purpose, for ascertaining the said, this court would like to first deal with the facts which led to the filing of the instant appeal. The respondent numbers 1 and 2 herein as plaintiffs had filed a suit for the purpose of convenience. This court would refer the parties in the same status as they stood before the learned trial court. The plaintiffs, who are the respondent number 1 and 2 in the instant proceeding, had instituted a suit seeking declaration that they have 7/72 or 7/72 share out of the total properties mentioned in Schedule A, B, C, and D to the plaintiff. Semicolon for declaration that each of the defendant numbers 1, 2, and 3 will get 7/72 shares out of the total property. For declaration that each of the defendant numbers 4, 5, 6, 8, 9, and 10 is entitled to 7/144 share. For declaration that the defendant numbers 11, 12, and 13 will jointly get the share of late Nurul Amin Khan, that is 7/72 share. For preliminary decree of partition, for an order that appointing the Deputy Commissioner Gwalpara as Commissioner to make partition of the land and property mentioned in Schedule A, B, C, and D, for final decree of partition, etc. The case of the plaintiff, in short, is the that one Abdul Latif Khan, since deceased, was the owner and possessor of a plot of land at measuring 3 katha 17 lecture, standing in 4 different pattas and 4 different dags, which is mentioned specifically described in Schedule A, Schedule B, Schedule C, and Schedule D to the plaintiff. Yes, got it, got it. Yeah, fire koi diya. The said Abdul Latif Khan expired on 31/12/2006, leaving behind 2 wives, 6 sons, 6 daughters. The plaintiff number 1 and the plaintiff number 2 along with the defendant number 1, defendant number 2, defendant number 3, and Nurul Amin Khan, bracket expired, were the sons of late Abdul Latif Khan. The defendant number 4, the defendant number 5, the defendant number 6, defendant number 8, defendant number 9, and defendant number 10 were the daughters of late Abdul Latif Khan. The defendant number 7 and the defendant number 14 were the wives of late Abdul Latif Khan. The plaintiff, both the plaintiffs who used to reside outside their hometown. And when they came in the month of March 2008 and asked one of his brothers, late Nurul Amin Khan, as regards the shares of their property. The defendants refused to give any share of the land and property to the plaintiffs. The plaintiff thereupon, after making inquiry, come to learn in the last part of December 2008 that the names of the defendants have been illegally recorded in the revenue record without recording the names of the plaintiffs. It is under such circumstances the defendant, the plaintiffs have filed a suit seeking partition. The defendant numbers 1, 2, 4, 5, 6, 7, and 7 jointly filed their written statement. In the same written statement, a plea was taken by the defendants that the entire land under original patta number 91 Dag number 35, that is totaling to 2 katha 15 lectures, was orally gifted by the to the defendant number 2, bracket the schedule B land. Defendant number 1, schedule D land, and late Nurul Amin Khan, schedule C land, and gave delivery of possession. Subsequently, they partitioned the said Dag number 35 by creating 3 new pattas. That is patta number 362 of Dag number 1014, patta number 363 of Dag number 101, and patta number 95 against Dag number 35. From a perusal of the written statement, it seemed that the defendants have contested the suit primarily on the ground that there was a gift, oral gift, made by the father, made by late Abdul Motin, what is his name? Abdul Motin Rahman, Latif Khan, in favor of the defendant. On the basis of the pleading, as many as 11 issues were framed. The said issues are reproduced here in under page 22. On behalf of the plaintiff, 4 witnesses were examined and certain documents were exhibited. On behalf of the defendant, 4 witnesses were also examined and various documents but 4 witnesses were examined. However, the documents so filed by the defendant were not exhibited. The learned trial court, by its judgment and decree dated 10th of April 2014, decreed the suit, passed a preliminary decree to the effect that the defendant number 7 and 14 each are entitled to 9.6 lectures. Plaintiff number 1 and 2 and defendant numbers 1, 2, and 3 each, and the legal heirs of the deceased Nurul Amin Khan were entitled to 4.62 lectures, and the defendant numbers 4, 5, 6, 8, 9, and 10 each were entitled to 3.2 lectures. On the basis of that, the suit was, the directions were issued to the collector for making partition in terms with section 54 of the Code of Civil Procedure 1908. So, being agreed, an appeal was prepared which was registered and numbered as title appeal number 6/2014. The first appellate court by the judgment and or decree dated 24th of June 2015 dismissed the appeal. Taking into account the substantial question of law which have been formulated, this court finds it relevant at this stage to take note of the decision in respect to issue numbers 5, 6, and 7 by both the learned trial court as well as the first appellate court. The learned trial court, after taking into account the evidence of the witnesses and that the defendants have failed to prove the three requisites for grant of an oral gift, which are essential for an oral gift, held that there was no oral gift, and accordingly decided this suit in favor of the plaintiff. The first appellate court also, while deciding the issue number 5, 6, and 7, categorically decided to took note of the evidence of both the parties. And came to an opinion that the defendants have failed to prove that there was a valid oral gift in favor of the defendants. In the backdrop of the above, let this court now take note of take note of as to whether the substantial question of law so formulated by this court on 2/5/2016 arises in the instant appeal. The said substantial question of law relates to as to whether the defendants failed to prove oral gift in terms with section 149 of the Mohammedan law is perverse. First, it is relevant at this stage to take note of that it is well settled that there are three essential elements which are necessary for a valid gift under the Mohammedan law. They are: A, the gift has to be necessarily declared by person making the gift, that is the donor. B, such a gift has to be accepted either impliedly or explicitly by or on behalf of the donee, semicolon. And C, apart from declaration and acceptance, there is also a requirement of delivery of possession for a valid gift. It is also very well settled that the requirement for validity of a gift are sequential. That is, one must follow the other. The later conditions can hold good if the first one is complied with. In other words, if A is not complied with, B and C would not be of consequence. Similarly, if A and C are met without B, it would still be of no consequence. In the end, all the three conditions must be met sequentially. It is also relevant to take note It is also relevant to take note of. A judgment of the Supreme Court in the case of Rasida Khatun versus Asik Ali, reported in 2014 10 SCC 459, wherein the Supreme Court observed the three essential features for a valid gift which are required to be satisfied. Para 17 of the said judgment is reproduced herein below. In the backdrop of the above, let this court take note of as to whether the defendants were able to prove that there was a valid oral gift. There is not a single whisper in the written statement that there was a declaration made by the donor about the gift. What is being stated in the written statement is that late Abdul, what is the name? Abdul Latif Khan had orally gifted the land, the suit land, and had delivered possession. In the procedure, in the evidence of the DW 1, 2, 3, and 4, it is seen that the witnesses who are the defendants, who are the witnesses, and more particularly the donee, was not aware as to when the gift was made or before whom the gift was made. There is also nothing mentioned even in the evidence that there was a declaration made by the donor. Under such circumstances, the first essential condition that a gift has to be necessarily declared by the person making the gift, that is the donor, is not met. Consequently, the second aspect, as regards the gift being validly, impliedly, or explicitly accepted, or there is a delivery of possession, holds no consequence. In that view of the matter, it is the opinion of this court that there is no perversity in the finding of the learned trial court both the courts below, that the defendant have failed to prove the three essential requisites of a valid gift. Considering the above, the substantial question of law so formulated in the opinion of this court is not involved in the present appeal. Consequently, the appeal stands dismissed with costs quantified at rupees 11,000 LCR being withdrawn. Right. Now your counterclaim has been dismissed. So once your counterclaim is dismissed, you cannot get a sale deed. Then what happens? How will you have a title over the land?
Because by, even though my counterclaim is dismissed, but as per exhibit A, exhibit 1A, there was an agreement by which the was agreed to sell the land. And that will prevail.
Hmm?
That will prevail exhibit.
That will 53A will only come into the scene to protect you.
Because
Will be
that,
only protected. It is nothing more than that. 53A only is a protection to you to the effect where any person contracts to transfer for consideration any immovable property by writing signed by him or on his behalf from whom the terms necessary to constitute the transfer can be ascertained with reasonable certainty. And the transferee has in part performance of the contract taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding that where there is an instrument of transfer, the transfer has not been completed in the manner prescribed therefore by law for the time being enforced, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and the person claiming under him any right in respect to the property of which the transferee has taken or continued in possession other than the right expressly provided by the terms of contract. That nothing in there shall affect the rights of the transferee for consideration who has no notice of the contract or the performance thereof. Let us read the exhibit 1A.
লিখিতম শ্রীমতী পরি দাস, স্বামী অতহু, খগেশ্বৰ দাস, বিশ্বধৰ দাস, লোহিত দাস, উভয়ৰে পিতা অংকুৰাম দাস, বৰাবৰ শ্ৰী মাধৱ দাস, পিতা পেঞ্চো, দৰা কোহৰা, মৌজা মদাৰতলা থাকে। শস্য জমি বিক্ৰী চুক্তিপদম কাৰ্যন চাগে। আমি মোৰ টকাৰ আৱশ্যক হোৱাত মোৰ নিজা নামে নামজাৰি স্বত্ব দখলত থকা নিম্ন তপশিল বৰ্ণিত জমি আমি বিক্ৰী কৰিবলৈ প্ৰস্তাৱ কৰাত উপৰোক্ত বৰাবৰে খৰিদ কৰিবলৈ প্ৰস্তাৱ দিয়াত আমি উভয় পক্ষই দেখি মিলি আজি ইমান তাৰিখে 13/1/2001 তাৰিখে চুক্তিপত্ৰ সম্পাদন কৰিলো। টকা থাকে যে নিম্ন তপশিল বৰ্ণিত জমিৰ মুঠ মূল্য প্ৰতি বিঘাই 1 লাখ হিচাপে ধাৰ্য কৰি বিকৃত জমিৰ জমি 1 বিঘা টকা মূল্য মুঠ 1,20,000 আজিয়েই বৰাবৰক চমজাই দিলো।
Now, there seems to be some overwriting. Moot 1,20,000
Yes.
and 1,20,000. So,
তাতে বুজি পাই আজি জমি বৰাবৰক চমজাই দিলো। ইয়াত আমাৰ কোনো ওজৰ আপত্তি নাই। উল্লেখ কৰে যে উক্ত জমি আমি কাৰো ওচৰত বিক্ৰী বন্ধক আদিৰ দ্বাৰা দায়গ্ৰস্ত কৰি ৰখা নাই। বৰাবৰে তেনে প্ৰমাণ পালে এই জমিৰ বাবদ বা মুঠ টকা ঘূৰাই দিবলৈ বাধ্য থাকিব।
in the second paragraph, উল্লেখ থাকে যে উক্ত
টকা
জমি
থাকে
আমি কোনো
উল্লেখ থাকে যে উক্ত জমি আমি কোনো কালে কোনো কাৰো ওচৰত বিক্ৰী বন্ধক আদিৰ দ্বাৰা দায়গ্ৰস্ত কৰি ৰখা নাই। বৰাবৰে তেনে কোনো প্ৰমাণ পালে এই জমিৰ বাবদ লোৱা মুঠ টকা সুদ মূল ঘূৰাই দিবলৈ বাধ্য থাকিব। অন্যথায় আইনমতে
this line is very important. বরাবরে and where is the possession being given in this document?
Paragraph 2 লৈছো।
Huh?
Paragraph 2 টকা থাকে যে নিম্ন তপশিল মূল্য প্ৰতি বিঘা ইমান ধাৰ্য হিচাপে বিক্ৰী জমি
Basic problem is signature of all the seller. All the
হাতে
seller did
হাতে
not sign.
গণি বুজি পাই আজিয়েই এই জমিৰ বৰাবৰক চমজাই দিলো।
Out of 4 seller, only 2 sellers could sign.
This is the so জমি আমি কোনো কালে
বৰাবৰে তেনে কোনো প্ৰমাণ উল্লেখ থাকে যে উক্ত জমি আমি কোনো কালে কাৰো ওচৰত বিক্ৰী বন্ধক আদিৰ দ্বাৰা দায়গ্ৰস্ত কৰি ৰখা নাই। বৰাবৰে তেনে কোনো প্ৰমাণ পালে উক্ত জমিৰ বাবদ লোৱা
there is a proof to that effect that it is being done with somebody, then we will return them. That is what it is. But where is the possession being handed over here?
সেইটোতো হাতে হাতে গণি বুজি পাই আমি আজি এই জমি বৰাবৰক চমজাই দিলো। Second part,
They me with I, me So when will they execute the deed of sale?
Hello?
When will they execute the deed of sale?
He's,
Because if we see section 54, it says the second part, an agreement for sale does not create any title or any right over that. It is only a document by which you can get another document. The agreement for sale. Now, where is it mentioned that they are going to execute the deed of sale? In this document?
there is,
How can you say this to be a document for agreement for sale?
Well, also very top silver. Because of the top silver. Just
Ah.
below top silver.
Yes, we did.
কামৰূপ জিলাৰ মদাৰতলা মৌজাৰ অন্তৰ্গত দৌৰাপাহৰা গাঁৱৰ তিনিশ নং পাট্টাৰ ছয়াংশ দাগৰ মুঠ 6 বিঘাৰ কাঠ 1 বিঘা 1 কঠা বিকৃত জমি হয় বিকৃত জমি হয়। That is why the learner trial court as well as certificate court also this is unregistered agreement.
It is not an agreement, it's a sale deed.
Shall be. That
But
is-
this, if it is, it does not say, although it may say to be an agreement on top. 50 Noma, 50 Patro. But when there is no contract to sale, then how can you get the benefit of the 53A?
And 53 requires your honor, vendors must be signed. Vendors or his behalf must be signed. Here out of 4 sellers, logic will find there are 4 sellers. Mori does, Forgesser does, Amphadhar does, and Lohit does. Here only 2, out of 4, only 2 vendor has was put there as a person, not other. So this is itself is not a.
Now, this document may at best show that there is a possession. Their possession is with them because in terms of section 49, one can take it for collateral purposes.
That must be admissible lordship. Subject to overcome the of evidence that admissible, that must be admissible.
Each document would not affect. You can look into the document as a sale document. But it can still be looked into for the purpose of 49. Means for collateral purposes. Collateral means there is a possession being handled. How he got the possession. That can be looked into. Yes. But when it does not say anything that it is there will be a sale deed executed, then how can it be said to be an agreement for sale?
Agreement for sale must consider some terms and conditions. for
Let's
both
read
the parties.
read the second part of section
Yes.
54.
In case of how to sell
No, second part.
contract. Contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. That's a contract.
But if this agreement does not say that there will be a sale or sale deed will be executed, it says that from now onwards, we will have no right over the land. It says that I will have no right over, what you call, the land is being sold. But there is a possession being handed over. So now read 49 of the Registration Act.
Categorically disputed.
Ah.
Effect of non-registration of documents required to be registered. No documents required by section 17 to be registered shall A, affect any immovable property comprised therein, or B, confer any power to adopt, or C, be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. Next.
Provided.
marriage. Provided that an unregistered document affecting immovable property and required by this act or transfer of property act to be registered may be received as evidence of contract in a suit for specific performance under Chapter 2 of Specific Relief Act 1877 or as evidence of any collateral transaction not required to be affected by registered stock. But it is there, my limited understanding also. It is only confined on registered, non-registered part. But admissibility part is something different also.
No, that they are in possession, that can be taken over. That is the core of it, that they are in possession. This can be taken as an agreement for the purpose that it is, for the purpose of, you see the language used. Be registered may be received as evidence of a contract in a suit for specific performance. So in a suit for specific, therefore they find the suit for specific performance. But there is no averment that there will be an execution of a deed of sale.
Yes, right. Other part is also not there. When refused, that part, when the vendor refused to execute sell deed. Those basic ingredients are not in the written statement of complainant.
And they say only that I've asked many times, but they have not executed.
Yes.
But the fact remains that there is no, because you have to mention certain dates when it has happened.
Yes.
Because this happened in 2001 and it happened in 2011.
Then, after 11, after filing my suit, only as a counter.
They filed this. No, but the question is, for the purpose of possession, it can be, but not for the purpose of a sale. If there is no averment in the sale, that there would be a sale deed executed, then can you convert a sale deed? A sale deed into an agreement for sale.
Definitely, if there is nothing to do any further, then that document is conclusive for the purpose to the extent of their right.
Because here 53A says, and the transferee has performed or is willing to perform his part of the contract. What contract?
No contract.
There's no contract there because there is no contract that there will be a sale deed. Merely because it has been mentioned to be a contract on top. Does it make it a contract?
Transfer of property act will come later. First, they will have to fulfill all principles under Indian Contract Act. Here, no contract is there, nothing to do any further. Then that document is coming.
So if there is no contract, so there is no question of willing to perform his part of the contract.
Exactly. That is troublesome. Decree will not at all applicable, particularly in this case, on the basis of that agreement. Release agreement.
But you did not challenge this agreement.
No, lots of, my case is something different.
Your case I've read it. Your case is that one fine day you went out there asking for 20,000 rupees and he put some on some blank paper and you don't mention anything about this agreement in it.
My only statement was on 15 February 2001. And that particular agreement for the different date. This, according to the counterclaimant's case, this was executed on
13/1/2001.
yes. And my case was something different here. Maybe your lordship kindly peruse paragraph 5 of my plan. Yes, here. Married
1 minute.
15 to 2021. There is a gap of 1 month, 2 days.
Paragraph 5,
Paragraph 5.
they took rupees 20,000 by mortgaging the said land. So that is what I'm saying.
So that is why fraud release. I have released fraud. That was
But you have not challenged the deed.
indication of fraud is there.
That's good, but not for what?
It is signed on blank paper. It was subsequently prepared.
So when he filed a counterclaim, did he file a written statement?
That's statement 5. Denying the same. Denied. Denied execution of that against that person. The burden lies with them definitely. And here two property is there. One, first, second property is concerned, Your Honor, they did not. In fact, they admitted that yes, that was mortgage, and in cross-examination also, DW1 said, I am ready to hand it over position subject to payment of money. Specifically admit. Furthermore, also this agreement portal is void as it.
You did not deny that you never executed on 13-1. Never executed any agreement for sale dated as such. So your entire case is of 20,000.
Only 20.
But why did the learned trial court come to a finding that you have taken 1,40,000?
What happened here?
But that's a finding of fact.
Just because
And you have not challenged it.
it was some of the defendants witness said that money was paid to the plaintiff. And the Ghana trial court held that on the ground of equity. But finally, there was the finding.
Equity is different. Equity is molding the ring. Sorry, but the fact remains that you have taken 1,20,000 is a finding of fact.
But in cross-examination, specifically PW1, the defendant side did not put single question on that time. No single question. So lots of time to tell you my whole process.
Of DW1.
In PW,
Who is the DW1? A play PW1?
PW1,
Who took the money?
for the sort of also PW1. We get it in
You are reading which one?
PW1.
Yes, yes, tell me.
মোৰ মাটি মই বন্ধক থৈছিলো তো plaintiffs stand on their own stand during cross examination. মাধৱ চন্দ্ৰ দাসৰ ওচৰত থৈছিল 20,000 টকা মোৰ বন্ধকী থৈছিলো 950 নম্বৰ দাগৰ 1 বিঘা 1 কঠা জমি আৰু আনটো দাগৰ 1 বিঘা জমি বন্ধকী থৈছিলো মই সুদ ভেলু 1,20,000 টকা লিখাৰ বিষয়ে নাজানো প্লেনটোত কি লিখা আছে নাজানো 15/2/2001 তাৰিখে মই মাধৱৰ পৰা 20,000 টকা লৈছিলো একজেক্টলি এজ ষ্টেটেড ইন পেৰাগ্ৰাফ 5 লৈছিলো এই সংক্ৰান্তত মোৰ ওচৰত কোনো প্ৰমাণ নাই পইচা লওঁতে মোৰ ভাই লোহিত আৰু মাধৱ দাস আছিল মই দুখন উকা কাগজ আৰু এখন হেডনোটৰ ওপৰত চহী কৰি টকা লৈছিলো
দুখন
মই দুখন উকা কাগজ আৰু এখন হেডনোটত if Lordship kindly peruse LCL And it's very surprising, Lordship. Agreement for sale exhibit 1A consists 3 pages. But that was written only first pages. Other 2 pages are blank. If your Lordship kindly presents for a moment. Exhibit 1. I have flagged it. Keep up your one. Yes, other 2 pages are blank.
Why?
In first page, somehow they manage it to complete the entire agreement for Elite agreement for sale. And other two signature of other 2 vendors were also not here. So I have also reduced my evidence on that point. So plaintiff proved their own case.
Further come. Point is one, proposal.
Exhibit 1A more sorry. মাধৱ দাসৰ পৰা লোৱা টকাটো মোৰ মা আৰু ভাই সংসদৰ দাসৰ হৈ লৈছিলো। মই মনু বড়োক চিনি পাওঁ। 6 কঠা জমি covered by ডাগ নম্বৰ 950 মনু বড়োৱে মাধৱ দাসৰ পৰা সাল সলনি কৰা জানো। মাটি বন্ধকি ৰখাৰ পিছত মোৰ মাধৱ দাসৰ লগত গৰু ধান খোৱালৈ পুলিচ কেছ হয়। পিছত SDO চিভিল অফিচ মই মাধৱ দাসৰ বিৰুদ্ধে আণ্ডাৰ সেকশ্যন 145 146 অফ CRPC কেছ দিওঁ। কিন্তু উক্ত 2টা কেছত মোৰ পৰাজয় হয়। বিবাদীয় জমিৰ ওপৰত কোনো গাঁৱৰ বিচাৰ হোৱা নাই। মাটি বন্ধকি থোৱাৰ বিষয়ে গাঁৱৰ লোকে নাজানে। বন্ধকি থকা দিনৰ পৰা মাধৱ দাসে জমিৰ পজেশ্যন আছে। সত্য নহয় যে 1,20,000 টকাত মই কোনো জমি বিক্ৰী দলিল চুক্তিপত্ৰ কৰা নাই। সত্য নহয় যে ডাগ নম্বৰ 86ৰ জমি মই মাধৱ দাসক 1 বিঘা বন্ধকি থওঁ 20,000 টকা। সত্য নহয় যে মই 6 বিঘা জমি 2 বিঘা 20,000 টকা মুঠ 1,20,000 টকাত বিক্ৰী কৰোঁ। মোৰ সাক্ষৰ এফিডেভিটৰ 5 নং পেৰাত কি লিখা আছে নাজানো। মোৰ সাক্ষৰ এফিডেভিটত মোৰ কোৱা মতে লিখা হোৱা নাই। In cross examination, the defendant side never put single question regarding sale, receiving one matlab execution of sale deed, NOC, nothing is there.
মোৰ নহয় 1,20,000 টকা মই কোনো বিক্ৰী দলিল চুক্তিপত্ৰ কৰা নাই।
Suggestion for you.
ডাগ নম্বৰ What does the second one say?
PWP Lordship answer her. Married
Who
Lordship.
is he?
He is also one of the parents.
He was also a signatory.
Hamshadhar are not, no Lordship. Only, yes, no. Lohit Das and Khorgeshwar. Hamshadhar not signatory.
Huh?
Hamshadhar Das is not signatory.
It is.
মোৰ হৈ খৰ্গেশ্বৰ আৰু লোহিত দাসে 20,000 টকা মাধৱ দাসৰ পৰা বন্ধকীৰ বাবে লোৱা মই জানো। বাকী টকা যদি খৰ্গেশ্বৰ দাস আৰু লোহিত দাসে আনিছে মই চাব যোৱা নাই। বন্ধকীৰ নামত টকা আনোতে মোৰ আপত্তি নাছিল। গাঁৱত আমাৰ ছাগলী বান্ধি থোৱা বিষয়ে আলোচনা হৈছিল মাধৱৰ লগত। প্লেন কিয় 1,20,000 টকা লিখিছে মই নাজানো। 1,20,000 টকা লোৱাৰ বিষয়ে কোৱা নাই। বন্ধকী লোৱা দিনৰ পৰা মাধৱ দাসে জমি ভোগ কৰি আছে। 6 কঠা জমিৰ 1 কঠা জমি মনু বড়োক সাল সলনি কৰি দিওঁতে গাঁওবুঢ়া আহিছিল। কিন্তু কেইজনমান লোকে অহা মই জানো। সত্য নহয় যে 6 কঠা জমি 1,20,000 টকা বিক্ৰী কৰা হয় মাধৱক আৰু 1 বিঘা জমি বন্ধকত 20,000 টকা লৈ মাধৱক দিয়া হয়। মোৰ দাদা খৰ্গেশ্বৰে নিপেন গোস্বামীৰ পৰা 4.7 কঠা জমি কৰিছিল কিন্তু ডেট মোৰ মনত নাই। সত্য নহয় যে মাধৱৰ পৰা লোৱা টকাৰে দাদাই নিপেন গোস্বামীৰ পৰা জমি কিনে। সত্য নহয় যে 6 কঠা জমি।
What does Lohit Das say? But why did the court then come to an opinion?
The plaintiffs did on their own cases. Yes, I have mortgaged, received money only 20,000 against that mortgage. Right? And in entire cross examination, which respect to only one property, there is 2 properties in the suit. If your lordship kindly permit,
And sale deed is for 2
only
properties.
first part, not second part. If your lordship kindly peruse page number 83. The plaintiff Counterclaimant sought specific performance in respect of first property. That is covered under 950, not in respect of the number 86. 86 are concerned, they also admitted in written statement.
And what is this? There are two topsil
Two
Why?
top- Plaintiff contention was
in the sale deed, in the agreement for sale, whatever may be exhibit 1A. Why there are two topsils, two schedules?
first of all, that number 9, not second.
So why is the other shipping for?
No, this is admitted. My case is admitted to the extent of second line,
Regarding what?
not good.
This is not a mortgage.
Second property is mortgage, admitted in written statement as well as cross examination. Yes, second property is mortgage and he is, defendant number in cross examination also admitted that he is ready to hand over second property. This only not really counter claim is concerned only first part,
There is
One-
1 bigha.
1 bigha, 1 section. That is covered under doc number 9. Not other part. Other
Doc
part
number?
admitted.
কয় কথা?
Yes, sir. This is covered.
কয় বিঘা?
Out of 6 bigha. One bigha, one section, out of 6 bigha. Second part, everything affected.
So for that you have to pay 20,000. No interest.
That is not. That is not.
Not my issue. Yes, Mr. Sharma, anything more?
Yeah, our case is basically we have paid money, which is almost 20,000. And this exhibit I have already read, that was exhibited, and possession was handed over to.
Possession handover, there is no quarrel. That can be only looked. But the fact that cannot be changed because the content does not show that it is an agreement for sale. It is a contract for sale. In fact, here, what you see, there are rights being created. If rights are created, then wouldn't it be whether whatever name you call it, whether it would not be require registration in view of the judgment of the Supreme Court in Suraj Lands?
Still is required, but so far 53 is concerned. 53A is concerned.
53A is you are willing to perform a part of the contract. Okay. What are you willing?
That part, of course.
You have performed or are you willing to perform a part of the contract? But then what is the contract? There is no contract here. I have given you. All land is being given. And we shall have no right whatsoever. So if the very existence of the contract is not there, it is a more like a conveyance. In fact, it seems to be a conveyance. If it is a conveyance, then in that regard, if it is not registered, if it is not no longer a contract, that is the difference between a contract and a conveyance. It's like a conveyance. If it is a conveyance, then under such circumstances, 53A will come in. If it is not registered,
The register is not about 53 is concerned. Yes.
53A normally it will does not require registration till 24/2001. From that day, the registration is required. Prior to that, registration was not required for 53A. There's no quarrel with that proposition. But for the purpose of that, what is the contract? If there is the creation of any right on the basis of this, that is therefore my first question is, what can you get? Means 53A is you are willing to perform your part of the contract. And on the other hand, the state, the vendor or the seller or the first party is not willing and he is trying to sell it to somebody or created some rights over to somebody over the land. Then he cannot enforce against you because of the fact that you are willing. So this is a protection which is being given to you. Willing to perform what? That is not there.
Of course, but it's
Without there being there, so 53A cannot come in. এখন দিবচোন আমাৰ temp console. That's just a judgment even. Now you see, this is one judgment which I got in the morning. A registered instrument styled release deed, releasing the right, title, and interest of the executant in any property in favor of a releasee for valuable consideration may operate as a conveyance if the document creates, discloses an intention to effect a transfer. Now, a registered instrument releasing the right of the lender without consideration may operate as a transfer by way of gift. And if the document clearly shows an intention to effect the transfer and is signed by two or more releasers and attested by two witnesses, Exhibit 1 stated that the releaser was the owner of the. So this was a case where there is a registered instrument. A conveyance includes a conveyance on sale and every instrument by which a property, whether immovable or movable, is transferred inter years and which is not otherwise specifically provided by Schedule 1. This is the conveyance defined. In the stat pack. Detail. So this is looks like a year whereby a movable or immovable is transferred intervals. Includes a conveyance on sale and every instrument by which a property whether immovable is transferred. So the moment it is transferred, they say that we have no right title. On the other hand, an agreement is different. Agreement has been separately defined. In the contract text, it will be there. Otherwise, you can very well fall back upon section 54, which defines the contract for sale. You have another document. We'll rise now. It's 1 o'clock. I won't spoil your lunch. Deliver the judgment today itself. But after lunch, I have some matter. After 3 o'clock, get yourself ready by. Can you hear me?
Good afternoon, Lordship.
On the third, that has not reached the learned CPM. However, my lordship has the learned CPM has.
That is what.
in front of him.
Madam, you see, on 3/3/2025, I passed an order. On that day, I've asked for two documents. The service book of the petitioner. And secondly, as to whether his name at the time of his appointment, did he supply the admit card as well as the pass certificate issued by the SEBA at the time of his appointment? Because you see, the petitioner is otherwise going to retire on 31/3/2025. So some urgent relief is required to be given if he's, otherwise it has been wrongly recorded in the service book. Okay? So you do one thing, provide a scan copy of the service book as well as the, as to whether at the time of his appointment, he had submitted the certificate as regards his date of birth, and what was the certificate produced?
May I please, Your Lordship?
Yes.
Lordship, we have the service book, but there is no document available basing on which the date of birth was mentioned there as 5/3/1965. There is no document available, Lordship. And Lordship, his initial appointment was done by District Judge Lakhimpur. At that time, Dhemaji was subdivision of Lakhimpur. So initial appointment was done by District Judge of Lakhimpur.
Okay, so you only have the service book.
Yes, Lordship.
Okay.
And as per the service book, that is his date of birth, 5/3/1965, as recorded in the service book, Lordship.
Okay, so you don't have any documents pertaining to his appointment?
No, Lordship.
Then we have to ask the district judge not looking for.
Sir, we made verbal communication after getting the order of Your Lordship. But as per verbal communication, they do not have any document.
Then how
Present.
did you enter the date of birth? Somebody has to enter the date of birth on the basis of something,
Yes, yes, Lordship.
isn't it?
Yes,
You
Lordship.
can't put the date of birth in key. So Mr. Hassan, at the time of your appointment, you submitted these documents.
My instruction.
Huh?
This is my instruction from my client, my lord. He
Ah.
submitted the admit card as well as the birth certificate.
Okay.
My lord, the impugn communication by which the prayer of the petitioner was rejected, nowhere it is stated that the petitioner did not supply these documents at the time of initial appointment. It was rejected on the ground that, my lord, it was-
But Mr. Hassan, did you say in your representation that you submitted these documents? If you have not said, why will they answer in that manner?
my lord, in the representation, I have stated that as per admit card, my date of birth is so and so, but it is blank
Understood,
admit
but
card.
did you say that you submitted this admit card at that point of time?
Specific that,
So then why will they answer to that effect?
but the rejection.
You asked that whether a person has gone to Delhi, would they say and did something in Delhi? And then you say that, oh, they didn't say that he traveled to Calcutta.
That the ground of rejection is something different. They have rejected.
No, I'm only worried out here as to whether these two documents were a part of it. If it was a part of it, or the second is as regards the authenticity of these two documents. How do we look into this aspect? Because normally this is considered to be the date of birth, isn't it?
Say, all the petition lists of all these years.
We are not concerned with that. Understood, whatever may be, but that does not mean, because a person otherwise will be losing around 3-4 years. Yes, so he having not been vigilant out here is not the question out there. The question is, somebody has put it in the service book, a date. Now, if these are the documents which are authentic documents, then the proper should have been on the basis of this. So we either Where can we find out, how do we find out that these documents are authentic, Annexure 1 and Annexure 2? You have the originals with you.
I can produce
Seba,
my- I can produce my-
No, not me.
Seba must come forward and say that. Secondary Education Board of Assam. Lordship.
And the accountant general only looks into on the basis of the service book, nothing more.
Sent to us, on the basis. But that time again, we may ask, the accountant general may ask, what basis you have entered the document? Because the service book will be provided to us. That time a question may come also, Milord.
That 100%, that question is going to come later on.
That is why, Milord, your lordship, it is, matter is clear today itself, by your lordship. Then we are not going to put any question on that point, because it will be, either is to be clarified by honorable court or by the documents. And here it is also.
Who is the counsel for SEBA?
Interesting.
Your lordship. It is.
Madam, who is the counsel for SEBA? Mr. Hassan, you know?
One maybe.
Yes, yes.
Here,
Sonia, Sana, Ram.
for twisted copy, Milord, though it is admit card. Then word is coming, reflection is there. Kamaleshwar, Uttaram, here Kirandra, something is
He has attested it.
tested. It's there. We are not
Therefore,
clear
you
also,
see
we
a
are putting
seal,
on this.
therefore you see a seal down there.
There is a, because
Down
we
there.
have, it is also not clear. That's why we are-
No, no, the question is, he will have to produce this document.
Yes, Milord.
There's no quarrel with that. The original, he will produce it. But I'm not on that. But how do we verify this authenticity of this document?
Authenticity will be.
Can be done
cleared
through
by the
SEBA.
SEBA only, Milord.
SEBA. Who is the counsel for SEBA?
Don't Chandra Sutia.
TC Sutia.
TC Sutia.
Where can I get him? So I ask somebody to ask him to be present after some time. Madam, you can, your appearance is dispensed with. You can carry out in your work, your official work. Okay?
Obliged, Lordship.
Ask Mr.
Scan copy will be required.
Required.
Ah. Madam, you provide the scan copy. You tell her. I'll put it in my order there.
I'll-
But only thing is, she says that it is not there. Now, should we make the district judge Hemaji not looking for a party?
Yes, but he'll also have to be made a party.
And in the meantime, I'll ask Seba. So ask Mr. T.C. Sutia to be present. No, I can very well, you see, there are two options. Either I say that he will produce the document and they will verify and do it. But the question is, if this verification is done through the other means, this means it may delay the proceedings, which may in turn will have an impact upon the petitioner. Because he otherwise will retire if it is not done. But if it is done through this court, it would be faster. So yes. Put together. So therefore, the question is, if we can get this verification done as regards the authenticity of these two documents, then I think it would be helpful. You get hold of Mr. Torun Chuti and get him. We'll take up the matter of
CJM Dhemaji, paragraph 6. Paragraph 6 of your lordship, page 8 of your, allegation is against the CJM Dhemaji.
No, this allegation is nothing to that. Because he joined somewhere else later on. At that point of time, it was the Dhemaji did not have it. So
It was-
it's okay. This is only, it has been recorded, he doesn't know anything.
But the one thing the petitioner has to satisfy, my humble submission before this on the court, is that he had no knowledge of the wrong entry matter all these years in service. It's that he has not seen this, that he has not protested this. Page 7.
What are
paragraph
you
12.
working as?
LDR.
Very well.
Madam, these dates of births are used on the basis of the 1st of March 1983. He was 16 years, 8 months. Okay. So how do you calculate this date of birth, and moreover taking into account the notification by which, if he is on the second date, its date of birth is on the second or any other date in the month, it will be the last day of the month, isn't it?
That is also.
The date of retirement. So these are all these problems which are, there are various notifications issued by the government in the personnel department. So therefore, maybe that these people may not understand that, but later on somebody must have told him, some clerk must have told him that this, you should have retired something more. You see, there are these type of matters, we don't go by those strict technical aspects. And then, first of all, whether this document is true. If the document is true, he should be entitled to. Nothing else.
Yes.
You get hold of Mr. Chupi and ask him to be present.
Item 4, fixed at 2 p.m.
Yes, what is this?
My lord, title execution case, that was rejected. Title execution case was rejected on the ground of limitation. That matter,
What was rejected?
on the ground of limitation.
Which order you are referring to? Which order you are
Case,
referring to?
case 45.
Oh, this one.
Fine.
Ah,
Whether that period will be excluded or not under section 15(1) of the Limitation Act. The record was called from by the Honorable Court. Now, what is the meaning of this stay order? My submission is stay order meant the postponement or the stopping of the judicial proceeding. It is postponed and stopped. Then that period may be excluded. That is my case.
see the 84 judgment
Fine.
which you are relying upon.
Fine.
84 judgment is on the point when it was partially stayed. Thereby you were stopped from executing it. 2001 judgment also does not say anything to that effect, but it says one thing, that you would not, if it goes against you, you do not get. But the question is, once the limitation starts under section 9, it continues, keeps on going on. And you can't take out unless the statute prescribes.
But in 84 judgments of similar situation arose. After 12 years, my lord,
There was a stay.
that's
Because of the stay, that is why I'm saying, normally section 9 gives a particular, once the limitation starts, it continues. Unless by way of a statute, it can be saved. 84 judgment is to that effect that by way of the statute, which is 15, it was stayed. And therefore, this period is to be excluded. 84 judgment further endorses another aspect, that your limitation period is 12 years. So within these 12 years, could it have been done? Now, during this period, around 3 years or 4 years, there was a stay. And because of the stay, this period was given back to you, was excluded. But if it is a record being called for, where you were not precluded from doing anything else, that's a different thing. But if the statute does not provide it, the exemption, which otherwise it continues under section 9. How do you take care of that situation? This is the problem with your case.
Ultimately, madam, I was restrained by that period.
No, you can. But the statute there has to be a statute by which you can exclude this period. And this is why the benefit is being given there. The only question in 84 is that he has filed it, then it got dismissed. And thereafter he has again filed it. The court said that even if this is being taken into account, this period will be taken out. Now, there is another judgment which is very relevant of Justice H.B. Sinha. There were two judgments. One is of Justice of Purushottam. This was the question arose in 2001 judgment of Justice S.B. Sinha. The question arose as to whether Purushottam judgment of 1917-19 was right or wrong. Purushottam is a case which squarely comes within the ambit of this case, wherein there was a decree passed. This particular decree, which was being passed, an appeal thereupon was filed. After an appeal has been filed, that appeal, there was a delay. And by this delay, the appeal was filed, the appeal was thereupon decided, and then there was a matter, went to second appeal. The second appeal, the appeal was delayed, and appeal was dismissed on the ground of delay. Then he said that the period has to be taken from the date on which the appeal got dismissed. The second appeal got dismissed because of the delay. The Supreme Court said no, it will start from 1978 in this case. This is the case of in Purushottam. Now the question arose in the 2001 judgment of Justice S.B. Sinha is what would be the impact in respect to an appeal being, originally there was an appeal, the decree, and thereupon the appeal was filed. But in this case, in 1986 or 87, the appeal was dismissed. And thereby, when the second appellate court had passed the decree, so whether this period, Purushottam's judgment will come in. So he said that no, it was filed within 2 years, it would not, because taking into account of the doctrine of merger. But here the doctrine of merger would not come in the case of Purushottam because of the fact that the appeal was dismissed. It is not a case of merger on the ground of delay, and as such it was held. Now therefore you see, these are the two different type of judgments. But in your case, the problem is, in view of section 9, the period continues. It can only be exempted if it is provided by the statute. And the statute only provides if there is a stay. That's the answer to your
That
question.
order, stay order.
The court having brought the records did not preclude it. That is a different thing, but the court should have stayed.
Should have stayed, but that is the
If the court did not stay, then you cannot take the advantage of that.
ultimately, I was restrained that period. Ultimately, I was restrained.
You were not restrained, you were not interested. That is why it got dismissed for default.
This subsequent one, it is subsequently made.
Can't help it.
Here in this case also, 84 case, it was dismissed for default twice,
Hmm?
after 12 years. In 84 case also,
Ah.
it was dismissed for default twice, after 12 years.
Yes, 84, if you see, the Anandilal, you see, includes partial stay of the execution. So here, the term 15.1, which states about stay, includes a partial stay also. So therefore, in that case, it was held that as there was a stay, you were precluded, and as you have this 12 years, the 12 years was given.
They include also partial stay.
Huh?
Stay includes partial stay also.
Partial stay, but here there is no stay.
Ultimately, the meaning of that stay, my lord, that is ultimately the postponement or the stopping the, my lord, the judicial proceeding. What does it mean? We are
You see, the difference is out there. You want this court to interpret the calling of the records to come within the ambit of a stay, which is not the legislative intent. The legislative would have otherwise mentioned it. By any other process, he is precluded from executing. That would have been mentioned. by the legislation. Now, if you want this court to add these very aspect of the matter into a decree or into a legislative code, I should contest elections.
It's correct, but here, but in paragraph 9 of that judgment, some reflection is there in paragraph 9 of that 84 judgment.
Yes. In Lala Bajnath, Prasad and so, the Calcutta High Court appears to have adopted a middle course. If a decree holder is prevented altogether from executing his decree, it is but reasonable that the time should not run against him so long as he remains disabled, and the section says so. But there seems to be no reason why the section should be construed as meaning that even when the injunction or order is limited to one or several of the judgment debtors or to one of the several of the parties, so if the seal, assuming state includes state in part, the utmost that can be claimed under the terms of the EI is that if a decree is restrained from for a time from proceeding against some particular judgment debtor or some other property waived, when the bar is lifted, he applies for execution against that so and so. He will be entitled to exclude the period during which he remained restrained.
When is in some particular way is under this.
We feel that there is no justification of placing a rigid construction or a beneficial provision on the so and so.
Restrained by some in particular way. I might not.
Here, in this case, paragraph, in this case, the subsequent case, 2004 8 SCC 724. Not Purushottam, it's Ratan Singh. Ratan Singh, here in Ratan Singh, possession of the property was obtained on 14/12/1970. The first appeal thereof against was dismissed on 1/8/1973. Execution petition was filed on 24/8/1988, that is beyond the time fixed by the Act. The second appeal prepared by the judgment debtor was rejected, having regard to the fact that the delay in filing the said appeal was not properly explained. Upon analyzing when a decree or order becomes enforceable vis-a-vis the definition of so and so, this court observed that when the dismissal of an appeal takes place on the ground of it being time-barred, no decree is passed. Ratan Singh therefore has no application in this case, in view of the fact that upon dismissal of the second appeal had drawn up a formal decree on 38/10/1986. In this case, the Chandra Prasad, that is the observations. Here it says, in paragraph 16, the substance of 48, because earlier it was 48, thus continues to be the law. It is the tribe that the provisions of the code and also the act has all along been considered to be supplemented to each other. It is also well settled that the execution of a decree should mean the enforcement of a decree by what is known as a possession. All possession proceedings in aid or supplemental to the execution will come within the meaning of the word execution. Keeping in view the fact that the first execution petition was maintainable at different stages of the same proceeding, but the same used to be filed within a period of 12 years from the Code of Civil Procedure, and the application was required to be made in a period of 3 years, this amendment is not disputed that all decrees by the original author are enforceable once a decree is sought to be enforced for the purpose of, irrespective of being original or appeal the date of the decree or any subsequent order directly in payment of the money. It is absolutely true that when a judgment is pronounced by the High Court in exercise of the appellate's power upon entertaining the appeal and a full hearing in the presence of both the parties, the same will replace the judgment of the lower court, and only the judgment of the High Court will be treated. It is prescribed under the statute of the appeal following the The dismissal of the ground of delay in filing the appeal is same is not condoned that the merger shall not. A limitation is not. Now, if you see Ratan Singh judgment is of 2001, 1 SCC 469. Finally, see section 5 also, very important. An appeal or limitation, an appeal or any application other than an application under any of the provisions of Order 21 may be admitted after the prescribed period. So section 5 is outside the scope. You cannot file. Other application you can file. An appeal you can file, not a suit. You cannot file a section 5 to a suit. Now, the only thing exemption is given under 4 to 24. Bar to limitation section 3, only 4 to 24 inclusive, subject to the provisions contained in 4 to 24, every suit filed beyond the period of limitation is gone. Now, you see, exclusion is only under 5. In computing the period of limitation of any suit or an application for execution of a decree, the institution or execution of which have been stayed by way of an injunction or order, the time of continuation of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded. So you want now that I should incorporate that the court having all the records will come within the ambit. This is a very difficult thing.
Or here might not the injunction or order. Here it is written stay by injunction or order,
Or order.
not conjunctive with disjunctive.
No. Or order. Therefore, there has to be an order. Order for stay. You see, there may be an injunction that you cannot proceed there.
That is 39.
Or there might be an order being passed to that effect where the execution is stayed under Order 41 Rule 5. Or under 227, the court may stay the execution proceedings. That period is to be excluded,
37 specific.
but not the entire thing. Because it will have far-reaching consequences.
I think the meaning of stay has not been defined. The word stay order has not been defined in cities or on a specific meaning. So what does it mean by stay order?
Now show me, what does it mean by stay order?
That is my
Then-
question, my lord.
No, you can't say that stay also means when you are incapable of doing anything, then you'll have far-reaching consequences. You are to satisfy, don't think that this court is going to satisfy myself by this. I have a habit of researching for myself. It's a different matter, but that doesn't mean that you are going to exclude yourself. Show me.
To my understanding, by stay
No understanding. in my understanding, calling for the records is no stay. Will have far-reaching consequences. You come up before the court unnecessarily and delay. And thereupon, you have to be more vigilant. Your conduct does not for this court to exercise 227 or 115. Well, the case is dismissed. Application dealing. No Seva Council.
He only comes. Lordship takes it up tomorrow. Directs.
It is item number 3, no?
Hearing.
It's the matter tomorrow at 2 p.m.
So in the name of Mr. Kiki Suti in the call, otherwise my
I
lord.
can I put his name? Tell me.
Otherwise, my
He's
lord,
not a party.
otherwise,
If you put this quote into people will start laughing. Eh? And in the meantime, if you can get hold of the scan copy.
Yes.
Item 6,
Yes, Mr. Chaudhary.
My lord, the primary issue that calls for your worship consideration is whether, my lord, the prior approval is required for feasibility.
For?
For grant for availing feasibility. There is a case, my lord, where the petitioner, she is a, my lord, copyist in the model exchange claims tribunal. She filed an application on 5th of January 2024, asking for feasibility for treatment of her child to come to Guwahati. That application, your worship will find at page 29.
What is the stage? All affidavits filed?
It is filed, my lord, was also filed.
Now, some departmental proceedings are going on. There is no stay. And why the departmental proceedings are going on?
My lord, since it was rejected, the application for legal leave was rejected, then subsequently she also filed an application for earned leave, converting that period and another law 30 days period that was rejected, and my lord, that has been treated as a subordination and a proceeding as well.
She working? How many days leave you have taken?
My lord, in fact, casual leave was for 4 days.
Then?
On 5th itself, my lord, it was rejected. In the morning, my lord, because of the illness of the child, she had to leave along with her husband to Guwahati for the treatment and laid the application, and also, my lord, sent an email. And my lord, it was rejected. Your worship will see, my lord, on the body of the petition itself, page 29.
Page
29.
29.
That is the type copy.
To honorable member, so and so prayer for casual leave of so and so. Then?
And then, my lord,
Rejected
your worship
petition
will see-
received at 10:49 a.m. after the employee left. This is the reason only. Is this the only reason? What is the reason?
So she is a habitual absentee. She is a habitual absentee. If your lordship kindly take up my affidavit, I have given the
Well,
details.
let us see your charge sheet. Where is it?
The show cause notice, your lordship will find at page 49.
49.
Application, there is 5-1 2024 rejected and you are asked to join your duties by Dr. Srajam Sassan said they did 5-1 2000.
Here we are concerned, your show cause is limited only to, why you are saying about habitual? Your show cause notice does not say anything about habitual. Why you can't bring in something else? Your show cause notice which was issued is strictly on a particular aspect
Yes, my lord.
that she gave, asked for casual leave, which was rejected, and the petitioner was asked to join, and thereupon she filed another application on 10/1/2024 for converting the casual leave into e-leave for a period of 2 months with effect from so and so for medical checkup. You have rejected it. Thereupon, she did not join. So therefore, you have initiated the proceedings. Now, did you see the
prior-
justification as to why she could not?
My lord, prior to that, your lordship kindly. Your lordship will also note, my lord, both the applications were rejected on the same date. On 5th, the first application was rejected. On 10th, she filed the earlier application. On the same day it was rejected. If your lordships kindly take my affidavit. And also not receiving.
No, your affidavit, you are saying about habitual. Why did you use the word habitual? We are not concerned because that is not the show cause notice.
No,
Your show cause
understand,
notice is specifically to 5/1, and then she asks for 2 months of leave. You may reject it. It is a different thing. You may reject it, you may ask it, because leave is not a matter of right.
Yes.
But the question is, when she said and she submitted a reply that to that effect, that she asked for AR because seeking leave was at 10:39. However, I submitted by along with the headquarters leave application on AR at 9:58, as was sent the hard copy on time. And she was having AR. Did she submit the medical certificates? Did you take your child back to the hospital?
My lord, the child was there, and thereafter, my lord, she had to continue in Guwahati. She had to continue in Guwahati.
Where? No, she's there in which place? Hubli.
What she did.
Huh? So no, you took the leave for what purpose?
For the treatment of the child. Treatment of the child.
So did you treat the child anyway?
Treatment is there, but there is no hospital. There is no hospital.
So somewhere you must have shown her. Where?
Guwahati, my lord, those documents, of course, my lord, that has not been annexed, but it has perhaps been given.
No, did you
reply.
furnish it to them at the time of reply to the show cause notice?
Because it appears not that the annexer, it doesn't show to have been annexed.
Oh, then there's a departmental proceedings going on. Face it and help it then. There's a departmental proceedings going on, very well go ahead then. You should have submitted these documents then and then. If that was because this notice was issued subsequently.
Notice has been issued on, my lord, the 19th of January.
On 19/1/2024, after the 10 days, you said that you had to leave because of 4 days, you had to leave out here because of medical reasons. Very well, you should have medical reasons mean something very urgent. You must have shown it to some doctor. Otherwise, obviously, you couldn't have, because otherwise Dhubri was there. So some other reason must have been there. But you say only out here that I had to leave. You're giving a justification to that effect. Not fully recovered as my baby was suffering from various illness from the last few days, starting from the end, and has not fully recovered, coupled with my baby illness which arose on Iman with rashes of the, and you have not, and non-availability of the local attending. I had left with the alternate area, went to Guwahati for medical emergency. Further, I being a influencer and had diabetic issue with so-and-so numbness in order to any further complication, I had no alternative, left the statement for my better treatment and sent my leave application. Then why did you ask for 2 months? Earn leave?
That application. Yes, my lord. At least 34.
Hmm? Now, what is the stage of the departmental proceedings?
In this application, my lord,
Huh?
medical documents have been shown to have been attached. It must be with them. Please 34.
Inquiry report given?
No, my lord. The inquiry is going on. Inquiry report has not been given as of now. There is no.
No, you want to draw earlier. There was some other departmental proceedings earlier.
Yes, my lord, there was one departmental proceeding wherein, my lord, penalty was imposed. That was also a case of unauthorized absence from duty. And that was challenged.
Mr. Chaudhary, the best thing which I can do is say that departmental proceedings shall go on and shall be disposed of without being influenced by the earlier proceedings. It's a good. Because you have not submitted anything. You can't help you.
Would the medical documents, my lord?
If it was the casual leave, only the casual leave question was there, then obviously this court is of the opinion, I am of the opinion that they should not be so touchy on 1030 or 1049. Isn't it? Because we normally get, there are a lot of things which we get it after 2-3 days. But every district judge, if he wants to have a station leave, he has to get our signatures, which is always done later on. We give it later on. Or anybody else, any person from the district, because I am a portfolio judge, have to give it later on. That is being done. But the question is, these are small things. But the question is, you have worked out there, you have asked for another 2 months of casual leave, which was rejected. So therefore, you have to explain your reasons before the authority, whether it is a case of insubordination or not.
Well, the first thing is that, my lord, the moment the application was received at 1049, my lord, it has been rejected. Secondly, my lord, this application.
Because you say on question of facts that you submitted at 9:58. Isn't it? So it is a question of proof. How do I decide? Tell me.
My lord, even if it is, my lord, submitted.
And I would have definitely,
later on.
and I would have definitely entertained your petition on if it was only on the casual leave. Thereafter, you ask for 2 months of earned leave. Now, if you have asked for 2 months of earned leave, whether it has been rightly rejected or not, that is another aspect of the matter. But they have initiated departmental, you have to satisfy that this is the reason why we have sought for.
One of the, in that application, the medical documents have been annexed by the application. Only.
But your reply to the so cause does not say so.
You know,
Which way?
I'm told by the previous one, in the final order will be passed in the day.
Hmm?
Final order in the disciplinary proceeding will be final passed in the day. The previous unauthorized absence was challenged before the summary court. It's that judgment, that is one judgment. And one judgment I have submitted, that is 2006 12 SCC 28. This is with regard to mere issuance of a show cause notice doesn't give rise to a cause of action for challenging that charge sheet unless it is without any authority or without jurisdiction. And the previous Unauthorized absence, you will also find this.
But as this absence is concerned, my lord, no medical certificate of the child was produced. And a medical board, she said that she was not keeping well. Then a medical board was considered. Joint Director of Health Services, my lord, they submitted a report. She is suffering from diabetes and blood pressure.
Who?
The petitioner. She wanted earn leave, saying that she was not medically fit. She is unfit. She was unfit. So a medical board was constituted wherein her health was checked up by the Joint Director of Health Services. And they gave given a report that she was suffering from high blood pressure and diabetes. These are all lifestyle diseases. It is the medical report. Sir.
My lord, that show cause that is notice has been issued before you my lord, gave the report of the my lord medical officer. She was asked to appear on 18/11/2024 before the
18/1.
medical board
18/1.
and 18/1/2024. And the so cause notice was issued my lord on 19/1/2024 before you get the report.
Report is dated 18/1.
Report no, she was asked to appear on the 18/1. That your worship will find at page 38.
Annexure R8 for me, my lord, I have annexed the report.
Before my lord, the report, with the report, my lord, already so called notice was issued. That's why my lord Nalapaidi has also been alleged here. And the my lord, the presiding officer has been made a party by name.
What is the malafide?
My lord, the moment I give an application, it is rejected. The moment I give the my lord the application for earn leave, my lord, it is rejected on the same day, my lord.
No, understood. What is malafide? In this case,
My lord,
is it a malice in law or malice in fact?
it's a violation, in fact.
They're
my-
making him, her a party by name. Obviously, it will be a case of malice in law. Fact.
Fact.
So what is your malafide
In
allegation?
fact is that, my lord, the moment it gets the application, it is rejected, even only by lord supported by medical documents, that is also rejected on the first day itself, and then my lord, they proceed in such a manner. Now, my lord, it is ready for the final, the, my lord, at war footing, my lord, the proceeding goes on. And
Our footing it is going on, it is good.
that is good for me, my lord.
Huh?
That is good for me, but at the same time, my lord, in the affidavit, they take a different stand. Someone has made a statement like this in another proceeding that is brought into my lord, the petitioner. The affidavit in opposition filed by the respondent number 3, my lord, that itself will show the malafide.
The petitioner is not getting any salary
He is not getting salary from February 2020.
till now.
He has not joined, my lord.
You not joined.
I can see working.
No, he has not joined. After that, once he left in the month of January, my lord, thereafter she did not join. So
Till now?
since she was not working, we had to stop her salary in view of the OM.
You have not joined.
I don't.
This is a case of insubordination.
For my instruction, that she is working.
Get your instruction. We have it on Thursday. Get your instructions
Whether
on the
she's
question as to whether this Thursday, next Thursday, as to whether she has joined or not. And you also get your
Yes,
instruction. If she has not joined, then I think we'll dismiss this petition. You have asked for maybe for earn leave out there. This is insubordination. Should tell. Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, submitted that the petitioner hearing have not joined since 5/1/2024. Taking into account, this court had inquired with Mr. M.K. Choudhury as to whether the learned senior counsel as to whether the petitioner have joined pursuant to 5/1/2024. As there is no order of suspension, there is no order of suspension.
No, there is no order.
He submits that he will take instructions. This matter again on 27th of March 2020.
I think that will, let them not file a party on the final order.
The council, I'm about to dismiss your petition for not joining and now you are asking for.
No, my lord, maybe your lordship will change your mind, my lord, after knowing the facts.
No, no, no. First of all, it is a case now for dismissal if you have not joined till now. You have taken the leave for 4 days, then it is okay. It was excusable. Then 2 months, okay, for some reason it could have been. Now, if you have not joined from then, this is a case of dismissal with force.
I have joined, my lord, your lordship may change your view.
So therefore, then I will consider.
In the meantime, we may pass the final order.
Then you have a good chance of filing another petition. I'm waiting here.
Much okay.
Yes, what is your matter?
The compensation that is being given.
Huh?
So compensation.
Will render reasonable and compensation. You are asking for enhancement.
Lordship.
Why?
So the lordship, while passing the impugned judgment, your lordship, the learned court below has only considered the surface damage. That is damage caused to the chimney that has to be struck down and some lamps and trees. But other factors that are there, your lordship, that has not been taken into consideration.
Other?
Factors like the diminution of the value of the land, then 15%.
And the records come here.
Hopefully that has not been justified.
Please, it's an option.
Whatever in this case, my lord, actually, before giving any opportunity to the local revenue authority, my lord, straightway they have filed an application under section 10D, my lord, for the land district of the lord. If that section 10D is not applicable to the district of the lord, it is section 16(3), my lord. Correct, but initially section 10D was made to the district magistrate. He passed an order to give reasonable compensation. His compensation was not.
ND for payment of adequate compensation per year. What did you ask for? This is for going on high tension.
Yes,
wire,
yes,
no?
I did the talk with that's 144 kV.
You asked for 81 lakhs. How much did you get?
3 lakhs. 3 lakhs.
Huh?
3 lakhs. 3 lakhs.
Why?
Okay, this is the matter. Nothing has been given on what basis, but suddenly an amount of rupees 3 lakhs will justify, and that's how the order was passed. If lordship takes up case number 57, the last.
What evidence you gave?
Himself, PW1, PW2, 4 evidence, 4 pieces are there with us.
You paid the 3 lakhs.
Only the Decretal land district has not, as per the judgment of the court margin.
3 lakhs. But that check has become non-negotiable.
I think he has received of
Huh?
He has received of that. He has received of.
You received that. Where is the judgment?
In the start from page number 49.
Page number
49. 49.
49. There is nothing on why 3 lakhs have been issued.
Nothing. Suddenly 3 lakhs will suffice.
Now, how will this court decide? I'm not exercising appellate jurisdiction. This is what jurisdiction am I exercising?
Division.
What revision?
There are two.
227. 227, I can only set aside this order and say that, okay, a judge, how much it is on the basis of evidence. Nothing more than that can I do. I can't change it and give you more than that. Can I give you more than that? You want the 3 lakhs or not? Return the 3 lakhs. Then. We return the 3 lakhs.
Then subject to outcome of the.
No, if it comes that you are not entitled to 30, because the amount was 38,000.
38,000 they have said.
That was the offer.
Even what is their stand in the WSA notice, according to them, I am not entitled to any compensation.
But then also they said 38,000, 30,000. But he
They
gave
have-
you 3
They
lakhs.
have not said, but when the records were come, the land.
Okay. We do one thing, we remand the matter back. You pay the 3 lakhs, 2,70,000 back.
It can be adjusted after the outcome, your lordship. Otherwise,
How?
it will be-
They only offered you 30,000.
That is correct, your lordship, but the determination that has been made, your lordship, without any, neither following the Supreme Court judgment, not the official notification that is in force also, your lordship. Something has to be there that these are the.
Heard Mr. So-and-so, the learning counsel appearing on behalf of the petitioner. And Mr. N.C. Das, the learning senior counsel, assisted by so-and-so appearing on behalf of the Power Grid Corporation of India. The instant application under Article 227 of the Constitution have been filed challenging the judgment dated 8/8/2016 passed by the learned court of the district judge Hailakandi in Miss Bracket PG case number 49/2012. The ground of objection taken in the instant proceeding, the ground taken in the instant proceedings is that the learned district judge Hailakandi, who had the jurisdiction to determine the compensation payable in terms with section 16D, 16(3) of the Telegraph Act 1885, had failed to exercise the jurisdiction and had perfunctorily awarded an amount of rupees 3 lakhs without taking into account the evidence which were duly placed on record. Mr. N.C. Das, the learned counsel, senior counsel, also submitted that the Power Grid Corporation, as per the Power Grid Corporation, the offer was given only for rupees 30,682. However, the learned district judge Hailakandi had awarded an amount of rupees 3 lakhs without any rhyme or reason. So, taking into account the above submissions, this court have also perused the impugned judgment dated 8/8/2016 and more particularly in respect to issue number 4. From a perusal of the said issue number 4, it is seen that the learned district judge Hailakandi have not decided as to why he has arrived at, why the learned court had arrived at the amount of rupees 3 lakhs and what is the had not come to a did not come to a there is no basis seen as to why the learned court had arrived at a finding that the compensation payable to the petitioner herein is 3 lakhs. Taking into account the manner in which the judgment dated 8/8/2016 was passed, impugned judgment dated 8/8/2016 is passed, this court interferes with the order dated with the impugned order, and thereby and further remands the matter back to the learned district judge Hailakandi to adjudicate afresh on the and determine as to what is the compensation, fair and reasonable compensation to which the petitioner herein would be entitled to. Taking into account that both the parties are represented, they are directed to appear before the learned district judge Hailakandi on 19th of May 2025. The on which date the learned district judge Hailakandi shall, on the basis of the evidence already on record and further upon hearing, giving an opportunity to both the sides to make oral arguments and, if so necessary, written arguments, dispose of the said proceedings in accordance with law. The records which were called for be returned to the court, to the learned court of the district judge, Hailakandi, by the registry forthwith, and forthwith, and shall make all the endeavors that the said records are available before the learned district judge Hailakandi on the next date so fixed herein above. E.P. বর্মন উপরত ধুমেকে বলতেন নাকি? Yes, Mr. Chaudhary, your matter. Mr. Chaudhary, I have looked into your matter, the substantial questions of law which you have framed.
Lord, there is a Supreme Court judgment, beloved.
Which one?
Yes, I'm giving that. Velikanu versus Singarumol.
Which year?
It's a judgment of 2005-6.
No, that I have looked into.
Yes.
That is a case which, these are the two cases.
No, Lord, Lords will kindly take note of 3 to 4 dates. 1/3/2001 was the date of conviction. Then, my lord, 12/5/2023, the sister, that is so-called plaintiff number 2, gave NOC. Then, my lord, 10/8/23, sale deed executed. After 1 year, that is 25/8/2004, plaintiff was acquitted by the High Court. So on the date the sale deed was executed, he didn't have any authority. In terms of section 25, read with section 27, he is presumed to have predeceased everybody. So what is the wrong in it? But most importantly, we submitted a written argument before the learned court below. We referred to 3 Supreme Court judgments. The learned judge, my lord, did not refer to our argument, and I do not know, my lord, on the day when the matter was reserved for orders, my learned friend was not present. And they said that it will be, they will make their arguments or written arguments will be fine. When written argument was submitted, when the other side argued the matter, we do not know. She relies on 3, my lord, Kerala High Court judgment. I'll distinguish each and every judgment, my lord. 3 judgments of Kerala High Court was relied upon. Our written argument was there. There is no reference to our written argument. But it's a sheer, my lord, misconduct with all sense of responsibility in making this submission. My lord, kindly see, 3 judgment was referred by the learned court below.
Conduct would not be a substantial question of law.
Yes. No, now substantial question of law, I'm coming to it, my lord. Now please have the judgment. In this case, what happened, my lord? This Velikanu, the defendant number 1 was guilty of murdering his own parents. Now he knew that he cannot inherit the property, so claim was made through his wife. There was a conviction. Thereafter, my lord, on appeal, on the ground of period underground, Milord, he was released. Please come to the facts at page number 624. Velikanu, para 2, page 624.
2005 6 SCC.
Yes, yes. If your lordship kindly comes to classicum Z on 10/10/72,
When we come to paragraph 18 of the same judgment,
paragraph
18.
of this judgment. Yes. Therefore, once it is held that a person has murdered his father or a person whom he wants to inherit, he stands totally dismissed. And kindly see my written argument, my lord. This was the paragraph we placed into service. Where is the reference to this paragraph?
No, I'm not on that.
Yes.
But the question is, would you say a person who has murdered
Yes.
anybody
Yes.
as a murderer or an accused till he is being convicted?
Yes, Lord, there are judgments. Kerala High Court judgment which the learned trial court relied upon. So he was not even convicted. If he is not convicted, things would be different. Merely because the charge sheet is there, you will not be a murderer. But once you are convicted, then my lord, justice, equity, and good conduct will come into. That's how the Supreme Court interpreted.
The Supreme Court went into the question of justice, equity, and good conduct, taking into account
Yes.
that prior to 1956, parliamentary provision like 25 was not there.
There, yes.
So therefore, in
Yes,
1932,
that principle was developed,
Privy
yes.
Council judgment, it was brought in about justice, equity, and good conscience. But the fact that a person cannot be said to be a murderer in a case unless he has been already convicted to that effect.
Yes, in this case, he was convicted, he was on
But
jail.
that conviction no longer remains the moment it is being acquitted.
On the date when the cell details are exit, then my lord, what meaning we give to section 34 of this specific relief act? Then he must seek declaration that he has a right title and interest over the land. Then only he can seek relief of cancellation of the sale deed. And my lord, importantly, one thing, this property does not belong to plaintiff number 1 alone. There are 3, 4. After the mother, there are 4 siblings.
Therefore, this is your substantial. This is therefore your substantial question of law, which is not there. The only substantial question of law,
Yes.
in my opinion, is as to whether the question is whether the learned trial court could have declared the sale deed to be null and void, or null and void, or should have only kept it that it's not binding on the plaintiff.
Yes, that also
That
one
is
of the way of looking at it.
the only substantial question. It should not have been declared to be null and void, taking into account that the plaintiff number 2, defendant number 1, defendant number 2, and defendant number 3
Yes.
have already sold the property.
Yes.
Now, as regards, because the plaintiff number 2 did not come to adduce any evidence.
Yes.
So therefore, the plaintiff number 2 cannot
And
come
her
up and say.
address was shown as that of Shillong, whereas she lives in the United States.
Never maybe, but tell me whether the plaintiff number 2's power of attorney.
Yes. Was exhibited.
Huh?
Only NOC has been exhibited, photocopy of the NOC.
NOC.
Not power of attorney, NOC.
No, power.
NOC,
What the power of attorney of the plaintiff number 2?
No.
No objection, sir.
How did because the power of the plaintiff number 2 did not execute the deed of sale. So therefore, the NOC may be given, but
Power of attorney.
so therefore the sale insofar as the plaintiff number 2 is also banned without anything, because there is nothing to that effect. The only sale which is good, maybe taking into account, is for the defendant number 2 and 3. They had 1/4 share of it. So
Half, that's right.
1/4 half. So these two sale deeds. So therefore the court could not have set aside the entire sale deed, but should have put it in terms with that they would also be remaining out there.
Then secondly, Lord,
44
secondly, which portion belongs to plaintiff number 1? Which
No,
portion
that-
belongs to plaintiff number two?
No, that can be very well taken care of by
No,
44.
but those are also questions to be gone into.
No, that will be gone into in terms with section 44 of the Transfer of Property Act,
Transfer.
whereby it will say that these people will be, the defendant number 1 will step into the shoes of defendant number 3 and 4, 2 and 3, and he will be a co-owner in respect to the property,
But
unless there
the
is a
problem
dwelling
is
house.
her mother had taken some loan. And the time was running out. That's the ground taken by the defendants number 2 and 3 in the written statement. And the defendant number 2 and 3 have also clearly stated in the written statement that plaintiff number 2, see, there was a telephonic discussion and it was affirmed that yes, you go ahead with the sale. That's why that NOC was given.
It should have very well executed a power of
Power of
attorney there. There couldn't have been a sale.
No, my lord, but the larger issue is, my lord, now the fact that on the date of execution of the sale deed, he was in jail, he was a convict. There was no stay from the Honorable High Court. What would be the consequence, my lord? Because in one of the judgment, Supreme Court has given one example, my lord, which I placed the other day. Supposing, my lord, I engage XYZ to kill my father. It so happened, my lord, during the course of the trial, I am sought to be made as an approver. So the person who killed, they will go to jail, I will go scot-free. And in that context, I will inherit the property of my father. Supreme Court says, no, you can't do that.
But he became an approver.
No, even that was disapproved. My lord, the trial court permitted that. High Court set aside, CBI went to Supreme
No,
Court.
if you know, you kindly see that judgment, which is, I think there is another judgment. You are
Yes.
referring to another judgment. This is CBI versus Ashok Agarwal.
Yes, CBI versus Ashok Agarwal.
Kindly see what is the language used by the Supreme Court. That
Yes.
is not the thing.
No, yes, my lord.
No.
It was a
Kindly-
case in the context of making somebody an approver. In that
Kindly come to
context,
paragraph 35.
yes,
of the same thing.
35, yes.
Once the
No,
immunity
my lord,
extends to
lordship,
the accused and the
get the
accused
minute,
is
lordship,
made an
and
approver,
read 34
he
together.
stands discharged, whereupon he ceases to be an accused and would have been examined only and unless here.
No,
Now
my
here
lord,
is
my
a
humble
case where
submission
he
is-
has accepted it.
No, my lord, to understand the purport of section 35, I think we'll have to read it together with 34.
Yes.
Because it is in that context only it was said. Now, after quoting, giving that example and quoting section 25, now this section deals with disqualification from inheritance of a person who commits murder or abets commission of murder. The provision of this section provides for a statutory recognition to Hindu law, wherein the rule is applied not only on the basis of text, but on the principle of justice, equity, and good conscience. The rule had been made applicable by all courts consistently, including this court, as is evident from the judgment in Velikanu versus so-and-so. Once the immunity extends to the accused, and accused is made an approver, he stands discharged, whereupon he ceases to be an accused and would be examined only as a witness unless the said privilege is revoked on violation of the condition of disclosing the complete truth. Thus, the illustration cited herein above, quoting section 25 of the Act, reflects the policy of law, and court must be alive to such a situation while passing an order, otherwise the consequence may be too abhorrent.
So let us take the example of a person has been unfairly convicted by the trial. Matter goes on in the High Court. We are fortunate out here that here the High Court finished up the matter in 1 year. That's it considered in the Allahabad High Court. Then after all these years, 10 years,
And you see, in circuit jurisprudence, when a person gets acquittal on benefit of doubt, then he's not absolved from his wrongdoing or a departmental proceeding. Now, here also in this case, my lord, on benefit of doubt, if once it is benefit of doubt, my lord, if you go by the purport of section 25, I don't think that will make any difference. I couldn't find any judgment on that point.
what do you want? I can decide on this point now and dismiss your appeal and go. Supreme Court may decide.
That's not the issue.
That
No,
is
my
the
lord,
issue.
end
Because
of the
if
day,
you
my lord,
want this
second-
question, I am not going to frame this as a substantial question of law. No, not to me. It's not a substantive question. Only question of law which I am going to frame is
Yes.
that whether the learned trial court or courts below were justified in setting aside the in spite of coming to a finding that
Yes.
the defendant number two, plaintiff number two,
And three.
three, no,
Sorry,
defendant number
defendant
2 and 3 had a share into the suit.
Yes.
That's it. There's an admission on their part. At that time, execution of Selvi's father was also alive. Because the property belongs to her mother, to their mother. On the death of mother, the property inherited by defendant number 2, 3, plaintiff number 1 and 2, and their deceased father, now he died. But the entire property has been sold out by the defendant number 2. Now, at that time, he was alive. That has been admitted by them, by the particular.
No, Mr. Bhuya, if the mother died, the father is also become a class 1A
Class
in
1A.
view of section 16. Now, the father's share would be automatically
At that time, execution of Selvi's father was alive.
understood.
Lots,
Father was alive, but the father did not execute.
lots.
It's okay. Father did not execute. But let us come to section 42, 44.
PPA.
The PPA. Insofar as the sale made to the affair with the proper. You see, where one of the two or more owners of a immovable property legally competent in that behalf transfers his share of such property or any interest therein, the transferee acquires as to such share or interest, and so far as is necessary to give effect to the transfer, the transferor's right to joint possession or other common or part enjoyment of the property, and to enforce a partition of the same, but subject to the conditions and liabilities affecting at the date of the transfer the share or any interest so transferred. So under such circumstances, yes, the father did not execute, but he had a share in respect, so the sale deed may be good in respect to 2 and 3,
2 and 3.
but maybe not good for others. So you will also have a right in respect to the property, but that property will be half of it. The plaintiff number 1, 1/4, and the defendant number 1, plaintiff number 2 will have 1/4. So that will be half of it. So what happens? The defendant number 1, in view of the sale deed, steps into the shoes of the defendant number 2 and 3. And
Not more than.
not more than that, and he will be entitled to seek a partition. That's what he can ask. But he cannot,
That can be asked.
that is the only thing he can ask.
Yes, not the entire property.
No. So therefore, if he has to ask for partition, now he's in possession of it. So the question is, if he has to ask for partition, then what happens as regards the consequence, therefore, as regards possession? The court had to pass an order for partition then. And without that partition, how will it happen?
But so for partition is concerned, because their claim is basically on the basis of a registered sale deed on the basis of entire property. So we file this suit declaring that the sale deed is null and void. They have from their side no counter.
No,
Their
it's okay.
side,
No, it's
no.
okay. No, I'm not on that. The question therefore should be that would the court have declared the entire suit to be sale deed to be null and void? or should have only said insofar as the share of the plaintiff
and
number
three is
1 and 2.
concerned, that is-
Plaintiff number 1 and 2 is concerned. It may be null and void or not binding, but not in respect to the others.
Well, plaintiff number 2 is not before the court. She was neither before the trial court nor here. The trial court plaintiff number 2 was never there. So, because she never came, Miller. She is all along in America.
He has been a plaintiff out there.
No, I know, only that much.
That question was raised before the trial court, Lordship.
You raised it.
Yes, that question was raised, and that was disbelieved by the trial court.
No, further to that, there is no power of attorney.
Photocopy of NOC was.
Yes, my lord, to the extent of there is no power of attorney, I am not disputing.
So therefore, the
But
share of the
my lord,
plaintiff
if
number
there's a
1 and 2
plaintiff
could
number,
not.
come for appropriate court,
Ah.
if necessary.
So plaintiff number 1 and 2 share it has to be diverted, and then because here we'll have a right. Or Mr. Ken Chaudhary, the learned senior counsel, assisted by so and so, appearing on behalf of the appellant. Instant appeal. There is an appeal by under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 14/11/2024, passed in title appeal number 39 of the 2022. The appeal is admitted by formulating the following substantial question of the following substantial question of law. Whether the learned quotes below, whether the learned quotes below were justified in
May I submit one thing, Your Lordship?
whether the learned quotes below were justified in declaring the sale deed number 7070/03 dated 10/8/2003 as void, illegal, inoperative, and not binding on the plaintiffs as void, illegal, and inoperative, without taking into consideration that the defendant number 2 and 3 in the suit had half share of the suit land and in view of section 44 of the Transfer of Property Act 1882 had the right to transfer that portion, their share. Call for the records. It is seen that Mr. R.K. Bhuiya appears on behalf of the plaintiff appears on behalf of the respondent number 1 and 2. 1 and 2. So copies of the memo of appeal be served upon him. The matter be placed before the court immediately upon receipt of the records. On 25/2025.
There's an IA of
25/2025. The registry shall take 40 steps for hearing. 25/2025 for hearing. Also, the registry shall take steps so that the records are available on the next stage. I Khandibo. This is an application filed under Order 41B5 of the Code of Civil Procedure for stay of the judgment and order dated so and so, decree dated so and so 14/11/2024, passed in title appeal number so and so. Taking into account that in the accompanying appeal has already been admitted by formulating a substantial question of law. This court stays the impugned judgment and decree till disposal of the appeal. And Mr. Bhuya, I give you the liberty for mentioning the matter for me. Because what is required is his appeal is to be allowed on this substantial question of law. But for that, what will happen is you may have to file a suit for this. So appeal has to be allowed. I would have allowed the appeal without the records. I would have allowed the appeal, but I can't on the first stage. We will now.
In fact, this ground was taken before the landed court. In my written argument, last ground was this, section 44.
So that portion is good. So this has to be allowed. So once it is being allowed, the matter is over. So then you may have to file a suit for partition. Yes, what is this?
Defendant respondent filed the title suit matter, number being 110 of the 10, possibly find at page 15 matter. This is a suit for declaration of right title interest matter and for recovery of khas position and vacant position of the street premises by evicting the defendant is regulations so and so.
Who filed the suit? Who filed the suit?
Defendant. The suit for declaration of right title interest matter. And what has happened, my lord? Their case is the suit. The suit land lordship will find at page 21, madam, schedule. The premise being the ground floor of two-story building, doing so, schedule is given. Therefore, what is my case? Lordship will find my request statement at annexure 2, madam, page 26, start from page 26. My case will lordship will find at page 25, madam, from paragraph F, madam. Madam, may I read, madam? The Motilal Ajit Sharia and Govind Prasad Ajit Sharia, they are uncle and father of the defendant, madam. Both says this is thereafter visited the defendant several times and made a proposal to him to lay fund.
No. Wait. I took up this matter on the ground that Mr. Kyle had on that date said that the suit was not maintainable because it was a landlord-tenant dispute and
Not at all.
landlord-tenant dispute and as such, section 100 is not maintained. But from the plaintiff, it is seen that it is not so. Because he is asking for right title interest over the suit.
Paragraph 9 of the plan, and the decree passed by the London trial court as well as by the towards my relation, I was allowed, actually was allowed to observe the report. Therefore, he said that I want to acknowledge you allow me for some months to as a clinic.
No, my case is denial.
Paragraph 9, page 7. Paragraph. It allows the defendant to state the conversion with nothing to do. In fact, on the office terms and conditions that rate to be considered in case that remains due to the defendant is 90,110. But the defendant is the brother-in-law of the plaintiff. So, they need to keep the security deposit of 25 free of interest, but agree to pay
Replace for security for the officer. And also may come to page 45. Page 45. Order of the-
Where is page 6?
Page 45.
Where is page 6 of the judgment? It is not clear.
Yes, my lord, I have seen, my lord, it's not there.
Ah.
In the, while giving the certificate copy, my lord, we have not been furnished with page 6, but I have checked the record, my lord. Even in the title living judgment, page 6 is missing, but the same is there in title suite judgment.
Because the issues are not here, na?
Yes, yes, number 1, you should consider to follow.
Two.
So, can you permit me then to get the, but I have checked. my lord,
Whether the plaintiff and the counterclaimant got right title and ownership of the suit premises. Whether the mutation of holding in any proof of title for the premises in favor of the plaintiff. Whether the defendant is liable for eviction from the suit premises. And this is the basis on which it is being done.
Interestingly, then that he was, as he went to the premises. My lord, what I will submit, my lord, let me submit, my lord. The things that my learned friend is showing, my lord. But the learned people never came to a finding, my lord, that, my lord, I am a tenant, because the kindly see page 6, my lord. Page 6, page 41, my lord. Page 41, my lord, page 41. There, my lord, while deciding the issue of with regard to causal action, my lord, Dorsey will find just 7 lines prior, my lord, while coming to a finding, my lord. As the right of the plaintiff of the suit premises is denied by the defendant, which the plaintiff asserts on the basis of title on the land on which the suit premises is standing, according to the plaintiff.
No,
the-
first of all, you do not admit that you are a tenant. Plaintiff is the owner. What is the document you have shown to prove your title?
He has had to prove it.
Forget about him. You are the plaintiff. What did you show for proving your title?
Actually, my lord, it is a kind of familiar. And in the cross, my lord, they have admitted that I have invested. In the
You are the brother-in-law.
Yes, he's our my brother, yes.
You are the brother-in-law. Property belong to whom?
Because my wife is also,
Property belong to whom?
but actually, I have given in the written statement, actually, because sale deed they have executed on the sale deed. That has not been discussed elaborately by the planet.
I'm asking you, who is the property owner of the
That
property?
I have admitted in the written statement that he is the.
No, you are not the tenant, so you have no right.
But thing
Matter
is
over.
that, my lord,
These cannot be substantial questions of law. Matter over. Why should we go?
because
No, Mr. Bakshi, the question does not arise. Once he is the owner, then the question it becomes if he wants to ask you to remain, if you are a tenant, then you are protected under the Assam Urban Area Rent Control Act.
then what
If you
about
are
my
not,
investment, my lord?
if you are not, then you have no right to remain in possession. Matter ends there.
Because there is an understanding, my lord. Also,
There is no understanding business.
the cross of the plaintiff defendant, what he has said, cross of the plaintiff, my lord. Kindly, my lord.
Loss of the plaintiff or defendant
Please
does
admit
not
it.
remain anything. These cannot be the moment you deny the tenancy, you say that you are the owner. Then you have to show that you are the owner. But when you have admitted him is the owner, then you have to recognize him is the owner, then you have to go out unless you have a right. You are a case of a permissive occupier then at best.
Yes, okay. My lord, also, my lord, I have annexed also some documents, my lord. What is that photo of the Nati? If I, yes, at the premises, right, and the Najib, laid down the law. Thereafter, he, one of the, his benefit came and he saw the, of the High Court where it stayed over. I know that I don't have any.
No, you have got the possession.
No, no, so now, both the, what is passed the order, so Najib did not hand over the position. The premises is vacant, I one law has been put by,
By whom?
The fact is reflected in the report.
He is not in possession.
Yes, not, but he has already left. It is,
I have not left, my lord. I don't have any instructions.
specifically instructed.
I have been in possession since 1980, my lord. 1984, my lord. Also, my kindly see page 25 of the written statement.
But this is, you say that this is a matter of landlord tenant, it won't come up. You won't take up this matter, these are 2020.
Lordship is to see the substance question of law.
Something, this substantial question of law doesn't happen, but the fact is, this court has take up other matters which are of more importance, pressing.
Lordship is to see the report, by report of the Nazi.
Okay. He's not there.
He's not there.
And that IA has been disposed of,
Yes, before the then
so I can't help you.
because while caveat that was also not taken the record. While caveat that was also not taken the record.
You file an IA for vacating. Take it up. Taking into account that the instant suit is not clear. This matter was directed to be listed today. The basis of the submission of Mr. Sikai, the level still appearing on behalf of the respondent, stated that the instant appeal is not maintainable in view of the fact that this was a landlord tenant dispute. However, from a perusal of the materials from report, I think that the perusal of the claim as well as the other materials from the report, it is that in the instance suit have been filed for declaration of the right title and interest over the suit land, suit premises. Consequently, in the opinion of the court, the appeal is maintainable 100 of the CPC. Mr. Esita, the learned counsel, has submitted that appellant presently is not in possession of the suit premises, as would be evidence from the report of the Nazir. And as such, in view of the stay which is operating, he may be operating, the Nazir has not delivered over the possession. He is given the liberty to file appropriate application if further for modification of the earlier orders. Not.
7 and 12.
Yes, what happened?
But I have received an instruction. But they said that they have rejected. And whatever calculation they have given earlier, they are stand by that. Possibly they may have some. This is the calculation they have given earlier.
No, I can't help that. I'm the executing court, what he is saying. Because you have not challenged that. Only thing which I can do, if you file an application before this court, I can, that you are going to pay this amount which has been given. Whatever this calculation is, how much? 8 minutes. How much it is?
What?
Total?
They said it is on 10/3/25. They said to be paid is 3,18,394.
No, you are giving us the same calculation,
That's
not this calculation. I have asked you to take that one, which
I
given.
I have sent the calculation given by them and along with the honorable court. They have responded that they have
What
rechecked.
should I do? I can do one thing. I can dismiss your petition out here thereby direct saying that this is the amount. This interest will keep on accruing, which will be more. The order of issuing of the precept is right. 11 years this matter is pending unnecessarily. Could have been finished then it would have been around 4-5 lakhs. এগুলা expert কোনগুলো ফুটবলে কি বলে? Skeptical ABCD XY ফুটবলে। Dismiss. Third, Mr. Be not the learning council appearing on behalf of. What do you want? You are not agreeable out there, this will dismiss it. This will again keep on accruing. 18% is not a matter of joke.
That's. So the our calculation, we have placed.
Your calculation is wrong.
And they have for the, given the calculation that I have said. They said that now they have reached it. They stand by the earlier calculation given by them. So I have to.
They have not stated anything to that effect. In spite of me passing that order, then also they want to override that. The executive engineer. I'll say this is right X on the basis of which he will execute. Third, Mr. The limit council appearing.
Only one of the one section probably 40%. So this decrease of 99, but it's a long one of the path. But if some negotiation on the interest can be done, if some liberty is given to us, if they are agreeable to that. Because
you have to negotiate which this court, I would not say, I've actually given you this opportunity. If you can negotiate good, but otherwise nothing is there. Therefore, I say that if you both come up and file an application before this court, they can close and freeze the interest. But if it is not so, and if Mr. Katunia was okay, he said that okay, the freezing may be given for this particular period of time, but if you are not agreeable, I can't help it. And if they say that the calculation is right, in spite of this court holding that his calculation is right, then I think heavens forbid, the rule of law has to take its course.
That's true. That's true. I have my limitation, but there is against the any instruction I can't submit. Although my
Anyway, no, I will therefore confirm these, what has been submitted, the statement, and on the basis of which the executive court shall proceed.
But in that case, the scope of negotiation will not be there.
No.
That will not be there. But
Not necessary. Let's
know.
say you have a lot of money.
I know where I stand.
You have a lot of money.
That is the difficult. But
These matters should have been disposed of then and there. It's matter why did it not dispose of immediately?
but, this plot I have received from the executive engineer today. Or I have received this from.
No, Mr. Nath, I understand. Fact remains that he is entitled to letting it. Why should I interfere out here?
That's true. That's true.
Heard Mr. Dinath, the learned counsel appearing on behalf of the petitioner.
Can I
And
can I
Mr.
can I
P.K.
take the
Patonia,
instruction
the
from the
learned counsel
CBI?
appearing on behalf of the respondents. This is an application filed under Article 57 of the Constitution, challenging an order dated 21/5/2014, passed by the learned civil judge, senior division Dibrugarh, in money execution case number 2/2011. This court has perused the said order, impugned order, dated 21/5/2014. Whereby the learned Civil Judge Dibrugarh, that is the learned executing court, had issued the precept for the purpose of recovery of the amount to which the decree holder is entitled to have issued the precept in money execution case number 3/2011 for recovery of the amount to which the decree holder is entitled to. This court further takes note of that prior to that, there is also another order passed by the learned executing court. That is an order dated 22/11/2013, wherein the learned trial court, executing court, had further detailed the reasons as to why the precept is required to be issued. The matter when was challenging those orders, challenging the order challenging the interim order, the instant proceedings was filed in the year 2014. Whereby the order dated 22/11/2013 and the order dated 21/5/2014, as well as money execution case number 02/2011, was stayed by this court. The matter thereupon did not come before this court. On 4/3/2025, when the matter was listed before this court heard the matter at length. And taking into account the judgment in the case of Gurpreet Singh versus Union of India, reported in 2006, 8 SCC 457, this court asked both the parties to place before this court their calculation as on their calculation as to how much amount the decree holder is entitled to. On 11/3/2000, and thereby fix the matter on 11/3/2025. On 11/3/2025, when the matter was taken up, the instant proceedings was taken up. The counsel appearing on behalf of the petitioner, that is the judgment debtor, have placed before this court a calculation which have been kept on record and marked with the letter B. And in turn, the decree holder, that is the respondent herein, have also placed before this court a calculation which have been marked with the letter Y. From the calculations so provided by the judgment debtor, it is seen that they say that an amount of rupees, how much?
But in
Huh?
in 45-24, we said
46.
in 46, we said 1,11,500.
1,11,544.
is paid.
On the other hand, the calculations were provided by the judgment degree holder, that is the respondent, shows that the degree holder, as on 11/3/2025, was entitled to an amount of rupees 7,90,928. You have the now let this court take note of as to whether the calculation submitted by the petitioner or the respondent is correct as per the judgment of the Supreme Constitution Bench of the Supreme Court in the case of Gurpreet Singh Supra. Paragraph 26 of the said judgment. 26, na? Of Gurpreet Singh, paragraph 26. 26 of the said judgment. Is relevant. And the same is reproduced hereinunder.
Yes, I was judgment.
That I will reply. But
Okay.
Gurpreet Singh, paragraph 26. Gurpreet Singh is paragraph 26. This court further finds it relevant to take note of another judgment of the Supreme Court. In the case of
Paragraph 24.
name, what is the citation?
Citation is 2013 1 SSC
2013.
1 SSC. Page 243. Paragraph 24.
In the case of BHEL versus RS Avtar Singh and Co. reported in 2013 1 SEC 243. Paragraph
24.
24 is before venturing to find out the answer to the question.
Paragraph is different because from Supreme today. But the reference is 2013 1 SSC 243. Last
Wherein the Supreme Court laid down the principles as to how the appropriation should be made towards a decretal amount. Paragraph 31 and its subparagraphs being relevant is reproduced hereinunder. From the above two judgments, it is clear that the general rule of appropriation towards a decretal amount was to be adjusted strictly in accordance with the directions contained in the decree. And in absence of such directions, adjustment be made firstly towards payment of interest and cost, and thereafter towards payment of principal amount subject, of course, to any agreement between the parties. It is further seen that if the payment made by the judgment debtor falls short of the decretal amount, the decree holder would be entitled to apply the general rule of appropriation by appropriating the amount deposited towards interest and then towards cost and finally towards the principal due under the decree. The accruing of the interest would only stop there would be no further interest on the amount. It would also be seen that it would also be clear from the above exposition of law that once some portion of the principal have been paid, have been appropriated, as regards that portion of the principal, there would not be accrual of any interest. In the backdrop of the above, this court have also perused the impugned judgment and decree. Have perused the judgment and decree passed in money suit number 19 of 2009. 19, na? Wherein the learned trial court decreed the suit for an amount of 2,71,164 with cost it was further mentioned that the defendant shall pay the deducted amount to the plaintiff within 3 months, failing which the defendant shall be liable to pay interest at the rate of 18% per annum from the date of filing of the suit till the date of recovery of the amount. The said decree so passed do not in any manner stipulate the manner of appropriation, and consequently, the general rule of appropriation, as have been held by the Constitution Bench of the Supreme Court in the Gurpreet Singh, in the paragraph quoted here in above, as a Gurpreet Singh Supra, as have been quoted here in above, as well as held Supra would apply. This court have duly perused the statement kept on record with the letter B submitted by the petitioners of the judgment debtors, as well as the statement submitted by the respondent, who is the decree holder, kept on record and marked with the letter Y. The manner in which the appropriation have been shown in the document kept on record and marked with the letter Y appears to be in consonance with the judgment of the Constitution Bench in Gurpreet Singh Supra, as well as Bhel Supra, as well as the Supreme Court in Bhel Supra. Consequently, in the opinion of this court, as on the date on which this court is passing the instant order, the petitioner, the decree holder is entitled to, and as on 11/3/2025, the decree holder was entitled to an amount of rupees 7,90,928. In view of the fact that the decree holder is entitled to the said amount, the decree holder is further entitled to proceed. The learned executing court was therefore justified in issuance of the precept by the impugned orders dated 22/11/2023 and 21/5/2000, no, 23, no, 22/11/2013 and 21/5/2014. In that view of the matter, this court finds no ground to interfere with the proceedings with the orders dated 22/11/2013 and 21/5/2014 passed in money execution case number 3/2011. Taking into account that there was a stay of the proceedings in money execution case number 3/2011 by this court, the said stay order is vacated and the parties are directed to appear. The records were called here. Isn't it record, huh? I know. I said, the parties are directed to appear before the learned executing court on 28th of April 2025. The learned executing court shall proceed with the execution case in the manner envisaged under law. The records which were called for, be forthwith returned by the registry of this court to the learned executing court. And so that the said records are available before the learned executing court on the next date so fixed by this court herein above. If this court further, for the sake of clarity, makes the document kept on record and marked with the letter Y as a part of the instant order, the registry shall issue the certified copy along with the said document marked with the letter Y.
Another case, next case also.
Same. That ABU, huh? A, and X. Kita amount
These
is
two cases, this document should be different.
that is, don't worry.
But my instructions I have received today. That may kindly be taken. My instructions which I have received today.
I don't want to go by that instruction because that instruction undermines the sphere of the court. When this court had categorically held out there very clearly that this is the right one, you were to therefore ask them, and they are not saying that that is right. Because that is the manner in which it is to be done. It's really to them. They are not agreeable, they will go there. I made it final here. So now it will go ahead unless you go to the Supreme Court.
But, the instructions which I have received.
Now interest will accrue again on that. If you go on.
Having item 14.
2009, we are in 2025.
But
Item 14.
the instructions received from the authority, and the instructions received from the authority. I have placed on the basis of instructions that I have placed. I can't go.
I understand your problem. The problem is that authority is not inclined. So let them therefore face the problem.
But
You
ultimately,
can't help some people who doesn't want the help.
kindly consider Lordship on 11/3, Lordship has passed the order. And in response to that, I have received the instructions. If it is not reflected in the order, then it will fall back on me that I have not placed it before.
So what? Now you say that. Don't
It-
worry,
it-
I'll put it.
It is not
No,
reflected.
I would not say. Would you want that I should say that the instruction says that there, in spite of me holding it to be right, then should I initiate contempt proceedings against that? Do you want, we can very well,
Not,
now we initiate a suo motu contempt proceedings against this executive agency.
I'm not on,
Well, let us do.
I am not on that kind of.
No, no, your say has been rechecked from this end to found to be correct, which means that you are categorically saying that my order is wrong.
No, that is not the, that is not.
Then?
On 11.3, on 11.3, logic, I have, the logic has ordered, passed the order, and we have requested them to verify, to do the re-verification.
They re-verification and they did this is the same thing which you placed on 10.3. I put it at the number A and B. So I said that this is not correct. And in spite of that, you have to, so you want I can initiate contempt proceedings against me. And show him the video. Ask him. They will know what you are saying. Now that's very good. It is open.
Or that, after 11.3, some instructions that has come, if it is not placed, ultimately it is.
You have placed it, but I don't want to put it out there because if I put it, I'll have to take action. It will look very bad if I don't take action. Which therefore I don't want to put that. If I put it, I'll have to take action.
Pending item 14.
Heard Mr. A.C. Sharma, the learned senior counsel, assisted by so-and-so, appearing on behalf of the appellant. And Mr. R. Ali, the learned counsel, who appears on behalf of the. How many respondents? Yeah, on behalf of the respondent numbers 1, 2, 1, 2, and 3. What about 4? Somebody died, na? Okay, 1, 2, and 3. The instant appeal is directed. It is filed under section 100 of the Code of Civil Procedure 1908, for short, the code. Challenging the judgment and decree dated 10/7/2015 passed by the learned court of the civil judge Kamrup Amingao, hereinafter referred to as the learned trial court, first appellate court, entitled appeal number 12/2014, whereby the judgment and decree passed on 10/10/2013 by the learned Munsif Rongia, entitled suit number 21/2010. Learned Munsif Rongia, hereinafter short the learned trial court. Rongia, entitled suit number 21/2010, was affirmed. It is seen from the records that the coordinate bench of this court had admitted the instant appeal by formulating a substantial question of law, which reads as under question mark. Whether the suit of the plaintiff is barred under section 53A of the Transfer of Property Act 1882, bracket, question mark. The question arises as to whether the substantial question of law, so formulated by the coordinate bench of this court by the order dated 26/2016, is involved in the instant appeal. For the purpose of ascertaining the say respect, this court finds it relevant to take note of the facts which led to the filing of the suit, filing of the instant appeal. For the sake of convenience, this court would refer to would refer the parties in the same status as they stood before the learned trial court. There were three plaintiffs. Three plaintiffs. How many people were the owner of this land?
Total 4, but mother expired.
Mother expired when?
Filing the legal statement.
No, in the plaint it is not there.
Yes.
So the mother did not file the suit.
Prior to filing the suit, Mr. Lordship kindly peruse paragraph 2.
One
1.2 sounds lordship.
Vatahu Ram Das, since deceased, was the original owner of a plot of land at measuring 2 bigha 1 katha, covered by dag number 86 and dag number 950 and included in patta number 300 at village Dharakhara under Moza Modol Tora in the district of Kamrup, Assam. The land included in dag number 950 had measured 1 bigha 1 katha 0 lesa, and the land included in dag number 86 had measured 1 bigha 0 katha 0 lesa. After the death of the father, the plaintiffs, along with the mother, inherited the property, the land, which have been more specifically described in the schedule to the plaintiff. It is the case of a plaintiff that a plaintiff number 1 and 3, with the consent of the plaintiff number 2, approached the defendant on 15/2/2001 for a loan of rupees 20,000 by mortgaging the land. However, the plaintiff did not execute any mortgage deed in black and white. Be that as it may, the defendant took signatures of the plaintiff number 1 and 3 on 15/2/2001 in blank stamp paper, assuring them that he will make a deed of mortgage specifying the conditions as agreed between the parties. The verbally agreed condition was the plaintiff, number 1 and 3, would repay the loan, and the defendant, who was handed over the possession, would return back the possession of the land. Firstly, it is the case of the plaintiff that the plaintiff wanted to pay the said amount of rupees 20,000 and wanted that the defendant should vacate the land and hand over the possession. However, the plaintiff did not do so. The defendant did not do so, did not accept the amount of rupees 20,000. They neither accepted the amount of rupees 20,000 nor handed over the possession back to the plaintiffs. It is under such circumstances, certain proceedings were initiated under section 145 and 146 of the CRPC, wherein the possession was declared in favor of the plaintiff, of the defendant. It is under such circumstances the suit was filed seeking declaration of right, title, and interest of the plaintiffs over the scheduled land for recovery of khas possession of the scheduled land by evicting the defendant, their men, servants, agents, employees, etc., and for permanent injunction restraining the defendant, their men, servants, agents, etc., from disturbing the peaceful possession, over the area by demolishing the boundary posts. The said suit was registered and numbered as title suit number 21 of 2010 and was endorsed for disposal before the court of the Munsif, Kamrup at Rongya, hereinafter referred to as the learned trial court. The defendant filed a written statement wherein various pleas were taken as regards the maintainability of the suit. In the said written statement, the defendant denied the plea, the case of the plaintiff, and further stated that on 13/1/2001, the plaintiff number 1 and 3 visited the house of the defendant accompanied by one Sri Nabojit Chandra Deka, Beckett petition writer, in order to enter into a sale agreement in respect to the land measuring 1 bigha 1 katha out of 6 bighas covered by dag number 950 of KP Patta number 300 of village Dhorakora under Muza Modartola. As per the discussion, Sri Nabojit Chandra Deka prepared the sale agreement dated 13/1/2001 in respect to the land measuring 1 bigha 1 katha of dag number 950 at a total consideration of rupees 1,20,000. And the plaintiff number 1 and 3 were present, had put their signatures on the sale agreement dated 1/13/11/2001. It was further mentioned that as the mother of the plaintiffs and Sri Hangshodar Das, who is the plaintiff number 2, were not present. It was informed to the defendant that they have no objections in entering into the sale agreement. It was further stated that in respect to the Schedule B land, why did Schedule A B? I don't understand.
Once,
In respect to the land mentioned, it was further mentioned that in respect to the land
one becomes the
that is 1 bigha covered by DAG number 86, the land was mortgaged at rupees 20,000 for a period of 1 year with a proposal of the plaintiff with a proposal that the plaintiff would have to repay the said amount within the period of 1 year. It was further mentioned that on 13/1/2001, the possession of the lands, both the lands, that is land covered by DAG number 950 and DAG number 86, as stated here in above, were handed over to the defendant. It was further mentioned that the plaintiff, that the plaintiff, however, did not execute the registered deed of sale in favor of the defendant, in spite of several requests made by the defendant. A plea under Section 53A of the Transfer of Property Act was taken by the defendant at paragraph number 14 of the written statement. It is further pertinent to mention that in the same written statement, a counterclaim was also made to the effect that the direction be given to the plaintiffs to execute the sale deed in favor of the defendant in respect to the scheduled land, which have been more specifically described in the counterclaim as Schedule A land. It is relevant to mention that the Schedule A land is the land which is covered by DAG number 900, the land at measuring 1 bigha 1 kata, covered by DAG number 950 of KP Patta number 300 of village Dhorakara under Modartola in the district of Kamrup. On the basis of the pleadings, the learned trial court claimed as many as 5 issues. The said issues being relevant are reproduced here in under. Be it as it may, it is at this stage, however, this court finds it very pertinent to observe that there was no specific issue framed in respect to section as regards the protection, as regards section 53A of the Transfer of Property Act 1882, as regards the claim of the defendant under section 53A of the Transfer of Property Act 1882. On behalf of the plaintiff, as well as the defendant, plaintiffs as well as the defendant, both sides adduced five witnesses as adduced the evidence of five witnesses and have also exhibited various documentary evidence. The learned trial court, by the judgment and decree dated 10/10/2013, decreed the suit in favor of the plaintiff, whereas dismissed the counterclaim. While deciding the issue number 3, the learned trial court came to a categorical finding that the defendant had no title over the suit land. And as the defendant has been possessing the said plot of land by giving rupees 1,20,000 to the plaintiffs in the year 2001, the said amount has to be repaid by the plaintiff in order to recover the possession from the defendant. As regards to issue number 4, the learned trial court came to an opinion that the defendant that the plaintiffs were not bound to execute the sale deed in favor of the defendant in respect to the Schedule A land by virtue of the sale agreement dated 13/1/2001 on the ground that it was barred by limitation. This court further finds it relevant to observe that the learned trial court, while decreeing the suit, observed that the plaintiffs were entitled to redeem the mortgaged land measuring 1 bighah covered by dag number 86 of patta number 300, subject to payment of rupees 20,000, as well as the payment of deficit fee as per law in the court. It was further observed that the plaintiffs are entitled to recover possession over the another plot of land at measuring 1 bighah 1 kata covered by dag number 950 of patta number 300, subject to the deposit of an amount of rupees 1,20,000 to the court, which will be delivered to the defendant. The plaintiff was It was held that the plaintiff would be entitled to get delivery of possession. The counterclaim so filed by the defendant was dismissed. Being aggrieved, an appeal was prepared. Which was registered and numbered as title appeal number 12/2014. An appeal was prepared by the defendant, who is an appellant. The said appeal was registered. was filed before the court of the civil judge, Kamrut Omingao, hereinafter referred to as the First Appellate Court, and was registered and numbered as title appeal number 12 of 2014. The said appeal was dismissed by the order dated 10/7/2015, thereby affirming the judgment of the learned trial court. It is under such circumstances the instant appeal has been preferred. I don't sit after 4:45. I'll give it tomorrow, day after, remaining day after. And I don't do CAB. So these are the two things. Otherwise, I can do it, finish it. But you see, Mr. Sharma, what order is to be passed is this. First, in terms of section 53A, there is a requirement of a contract for sale. I can even dictate it later on in my chamber. 53A, there can be a contract of sale, but this cannot be said to be a contract for sale. One. Secondly, 53A can only be claimed against the person with whom you have entered into an agreement, provided if there is considered to be agreement. But it cannot be claimed against another person who is not privy to a contract. So there are two judgments in the Supreme Court on this. On this basis, I am going to dismiss your appeal. So should I dismiss it back in my chamber?
And leave it to it.
And the two judgments are one is 2002 3 SEC 676, and the second judgment is 2004 8 SEC 614. These are the two judgments on which your appeal is going to be taken.
Another one is this.
Why do you want multiplicity of judgments?
202. Yes, it.
Yes, you give it 2002 3 SEC page 276. So what is that? Give it to you. Well, yeah, you do put it. This is what is going to happen. Yes, what is it? I don't entertain any request after 4:45, taking into account your bar members has objection, me sitting after 4:45.
Well, item
So I can't help.
16 and 17.
No, I can't help. I can't hear. My ears are closed after 4:45.